so I think we'll get started. Welcome to this morning's hearing on three separate matters relevant to the proposed Arecleoch wind farm extension. These are topic 3, ecology, specifically bats, topic 6, which is access, traffic and transport, and topic 7, peatland. For those of you who haven't taken part in any of the previous sessions, my name is Alison Kirkwood, and I'm joined virtually by my colleague David Liddle. We are the reporters appointed to consider the Arecleoch extension proposal and report to Scottish ministers. Now, can I first ask parties to introduce themselves? Mr. Stevenson, we'll go to you first, seeing you're on your own today.
Yes, Struan Stevenson. I'm a local resident and objector to the Arecleoch extension.
Thank you. And Mr. Thompson for the applicant.
Yes, my name is Malcolm Thompson. I'm an advocate and I'm instructed on behalf of the applicants. The representative who will be speaking today on behalf of the applicant is David MacArthur of MacArthur Green. And I've circulated again, I think this morning, a brief detail of each of the representatives' qualifications and career. But in essence, Mr. MacArthur is an ecological expert who will be answering questions today on the topic of bats.
And have you other representatives for the other topics?
No, madam. Sorry. For the other topics, Joanna Reid of SLR Consulting for topic 6. Again, she's a principal transport planner at SLR Consulting and is an experienced transport planner, having worked in the industry for 19 years. So she will be addressing topic 6 along with Tony Gannon of the applicant, who will be able to answer more factual issues. And then topic 7, Colin Duncan of SLR Consulting. He's a technical director, land quality in SLR's Stirling office, and he will be speaking on the topic of peat.
Thank you. Just continue with the preliminaries. I'd remind parties that the hearing is being broadcast live and then recorded for future viewing on our website. Please note that everyone is required to follow government guidance in relation to COVID-19. We will stop proceedings if we have any concerns in this regard. When you're not speaking, please have your microphone off, and for anyone just observing, can they ensure they also have their camera off. The hearing is scheduled to last all morning. We'll take one or more short breaks at regular intervals, possibly, if it works out that way, at the end of each of the topics to allow the applicant's representatives to swap over. After the hearing ends, we will allow sufficient time for Mr. Thompson and the reporters to have a lunch break. The afternoon hearing on topic 8 involving other parties will not commence before 1:30 p.m. But depends when we get finished this morning, what time we start this afternoon. But it won't be before 1:30 for those other parties. Now, both parties for this hearing have circulated lists of documents that they're likely to refer to. All of these are on the memory stick provided by the applicant, with the exception of documents CD 22.10 to CD 22.14, which were Mr. Stevenson's additional documents. Thank you, Mr. Stevenson, for providing these in a different format for us to open. And we've also now downloaded the PDF versions from the hub and put those onto the website. So thank you for helping us to resolve that, and to Emma Payton as well. Now, the hearing agenda, which you should all have, sets out those matters which the reporters consider would benefit from further discussion. This doesn't indicate that there other matters covered in written submissions which are less important. It's just we need to, these are the matters that we think we need further discussion on. We have all the written evidence before us and we will take it into account. So there's no need to repeat any of this just for the sake of it. But you can, of course, take us to it, help explain the point you're making. And you can ask questions of each other, but we ask that you do that through us. If in your answers you wish to take us to a relevant section in a document, please allow time for everyone to have that in front of this before proceeding. So we may need to take a short break and just check that everybody's got the relevant extract and the relevant document. Is everyone content with the agenda? Are there any procedural matters we need to discuss? Okay, in that case, we'll get started. So I propose we run in the order of the topics as set out, with the ecology first. So that would be Mr. MacArthur for the applicant.
In that case, I'll simply hand over to Mr. MacArthur. Thank you, Madam.
Thank you, Mr. Thompson. Good morning, Mr. MacArthur.
Good morning.
Do you have the agenda, and do you have the agenda in front of you?
Yes.
Okay. So the first question is about the impact of the proposal on the Leisler's bat. Now, can I first check if I pronounced that question? Is it Leisler, Leisler?
Leisler, yeah.
Leisler, thank you.
Leisler's fine.
So, Mr. Stevenson states that the death of a single Leisler bat from wind turbine collision should be prevented due to their rare status. In your response in section 2.1 of your hearing statement, you've concluded that a worst case scenario of pre-mitigation collision mortality is negligible in a population context. So we would just, as a start, like to invite you to explain that conclusion in a bit more detail for us.
Yeah, okay. Yeah, I can talk through how I've arrived at that conclusion. I guess in summary, what I'm saying is a predicted additional annual mortality of about half a Leisler bat per annum from the whole site is likely to have it's not going to have a detectable impact on the conservation status of that species when the population is about 5,000, or probably more like 10,000. And that estimate there's a pre-mitigation annual mortality as well. So I'll explain a bit later that once the mitigation, this curtailment mitigation is in place, that estimate is really very, very, very close to zero, so even more negligible. Just to give a little bit more background about how the assessment has arrived at this conclusion, I can just kind of go through the key details. So if you've got any clarification, any questions, please just interrupt. So SNH guidance, the SNH et al. Document, that's part of the core documents. I think it's CD 12.1. That does categorise Leisler's bat as a high population vulnerability, and that is due to their relative population size. The way it categorises bats is it's all relative. So they are higher vulnerability. So their population size is smaller than relative to other bats, and also their flight characteristics, flight behaviour. They're fast flying. Fast and high-flying bats, so in theory they're less manoeuvrable in terms of turbines, so they're potentially at a higher risk of collision. So that's why the SNH guidance does classify them as high population vulnerability. So the assessment method that's used in the guidance looks at that high population vulnerability, but the other side of it, of working out what the impact level is to look at the activity level of bats on the site. So looking at the activity level of bats at the Arecleoch site, the activity recorded on the site was low. And the way that's estimated, again, it's a relative measure as explained in the guidance document from SNH. But the way that relative measures come up with is a comparison of other relevant sites in the area. So in this case, the other relevant sites are 10 reference sites in southwest Scotland, which is the ideal reference area because this is the area where the Leisler population tends to exist in Scotland. So when you compare the activity of Leisler bats at Arecleoch with the 10 reference sites, Arecleoch is very, very low. So that's how we've arrived at a low activity, low population, low activity of Leisler bat in the site in relative terms. So I guess, a fair question to ask then is, well, what does that actually mean? It's low relatively, but what's it actually, mean in terms of collision at risk? So the factor that gives us, a lot of confidence in this conclusion is that the mortality searches that have been completed at these reference sites using a technique which is highly, it's proven by Exeter University, using trained sniffer dogs, and these sites pre-mitigation, so that not applying the curtailment mitigation, they found no Leisler bat fatalities at these sites with the turbines operating as normal. And then obviously they put in the mitigation, and there was still no Leisler bat mortality. So that's happening at these sites where you've got higher levels of mortality. So that conclusion gives us, it's a high degree of confidence that this conclusion that I've estimated based on the activity of the bats at the site and compared to the data that's been collected using mortality rates and activity, that the fractions of a bat per annum that we're talking about are very close to zero, or it's true, it's correct. So a high level of confidence in that conclusion. So that's why the negligible effect, especially post mitigation, has been arrived at.
Thank you, Mr. MacArthur. That's helpful to understand some of the information behind your study. Mr. Stevenson, I'll pass it over to yourself, specifically in relation to question one, because we'll come on to the impact of lighting in the next question.
Opening statement. Could I just perhaps pose the first question? From all the evidence that I've read, and I've researched quite intensively, particularly online, it seems to me that there is very little information about Leisler's bats, even over the past 20 years. There is dubiety about the extent of their migratory patterns. There's dubiety, as we'll come to later, about whether they're attracted during their feeding activities to red lights. There is certainly a question about the extent of the population of Leisler's bats, with some evidence, and I've referenced where I found this evidence, although it is quite old evidence, but Bristol University appears to think that this very rare species of bat, that there are only 250 of them in Scotland, not 5,000.
Mr. Stevenson, could I ask you to clarify what document number, just so that we have that whenever we're cross-referencing back to our notes?
Yeah, can I just scroll down till I find?
Yeah, take your time. I think there will be pauses while better that we get the information. And
CD 2211 is Natural England Joint Publication, a review of the population conservation status of British mammals, Leisler bats. That's one reference. The other one is the one I spoke about, the University of Bristol School of Biological Sciences, CD 2210. That dates back to 1995, but there don't appear to be very many accurate, more recent estimates of population levels. It seems it's very difficult to estimate the population of Liseless bat, but there is general agreement that this is a very rare species, particularly in Scotland. And I challenge the fact that Mr. MacArthur suggests there could be 5,000 of these bats. It is established that one of the few areas where this bat is known to exist, and Mr. MacArthur has agreed with this, is in fact in this area of South Ayrshire, and indeed in that adjoining part of Galloway. So when you consider that there is the likelihood of half a bat being killed every year, I find that estimate rather odd. But legally, if I was suggesting that I wanted to demolish a barn and applied for planning approval, and there were bats of any variety roosting in that barn, I would be denied planning approval. It is illegal. It's a criminal offence to kill a bat. So the very intention that you propose to kill even half a bat, although that sounds ridiculous, is in fact against the law. So I cannot see why there should be one law for Scottish Power and another law for the rest of us. It's also, when you talk about the mitigation factors, Mr. MacArthur, you're talking about switching off the turbines when they are feathering.
Mr. Stevenson, we're going to come to mitigation later on, because I'd like to ask Mr. MacArthur to explain the mitigation. So if you wouldn't mind parking that comment until then.
Okay, he did raise it, so yeah, I'll come back to that then.
David, sorry, do you want to come in?
Is it your intention to, Mr. MacArthur, to raise the question of other bats, when we're on this subject?
Mr. Stevenson, can I just come in there? I was going to ask you a question there.
Yeah.
You talked about the need for licensing. You touched on licensing provisions there, and it seemed to me that your argument there was, well, if I extend it slightly, are you saying that it would be unlawful for ministers to consent a wind farm if the environmental assessment suggested there was any risk of mortality of any bat? Do you go as far as saying that?
Well, it seems to me that it's illegal to kill a bat. It's a criminal offence to kill a bat. Is Scottish Power saying that the Arecleoch extension will not kill any bats? They are not, in fact.
Okay, but I asked you a question about what your position is. Are you saying, it seemed to me like you were saying that it would be unlawful to consent a wind farm if the predictions were that any bats would be killed over the lifetime of the wind farm. If you're only posing it as a question, then that's fine. But I'm just trying to understand, is that your position?
No, I am posing it as a question. But the other question that asked, are we talking only about liceless bats just now, or can we extend that to other bats?
We didn't have any questions in relation to other bats. If there's a particular point you want to raise, but the agenda was focused particularly on the impact on the Leisler bat. So it may be that Mr. MacArthur doesn't have that information to hand. But you could try and ask the question if you want, or make the point if you want, Mr. Stevenson. Then we'll see if Mr. MacArthur wants to come back and respond.
Well, it's. Okay. again, it's not only a criminal offence to kill a Leisler's bat. I would point out it's a criminal offence to kill any bat. And the common pipistrelle is also a bat that there are many more of them that is likely to be at risk in this area. I just wondered if when Mr. MacArthur was talking about his evidence that there were no Leisler bat mortalities discovered by sniffer dogs in existing wind turbines in that area, if he could say that that's the same case with other bats.
Okay, I think there's a few points that that Mr. Stevenson has raised that you may want to come back to in relation to the population of the Leisler bat and how rare it is, and secondly, if you want to comment on the mortality effects on other species of bats, that would be useful. Thank you, Mr. Stevenson.
Okay. Right. Well, firstly, just looking at taking Mr. Stevenson's question about the population size of Leisler's bats in Scotland. So in the environmental statement, we refer to one of the estimates that's been around for quite some time, as Mr. Stevenson mentions, is the sort of 250 bats in Scotland estimate, and then about 5,000 to 10,000 in England. And they are old estimates, but they are the volume of study that's been done in bats is quite hard to collect the information, but they're seen as very precautionary estimates of bat populations. I think one thing to explain is that it's false from a biological perspective to define a Scottish population and an English population, because these bats are known through radio tracking studies to disperse, which is different from migration, which we'll come on to. Disperse over long distances. So there's a lot of gene flow in between regions. So that the actual biological genetic population that's relevance here is the English-Scottish population that exists, which is estimated to be, a lot of papers talk about 10,000, but that's seen as a very precautionary estimate. So these papers are, they always err on the side of caution from a conservation perspective, because it's safer to assume a smaller population. So you're looking at a biological population that you have to consider. When you're thinking about mortality from a population, you have to consider how that biological population responds to that mortality. Now, in the environmental statement, the ecology chapter, we refer to, we say, 250 and reference probably a similar paper that Mr. Stevenson mentioned. But we see, there's other evidence suggests that this is a vast underestimate of that population. It's sort of a fairly recent paper, I think, on that topic is one that in SNH produced in 2017, which estimated Leisler bat populations by sampling different grid squares in Scotland, and they came to the conclusion that you're looking at a population in the thousands rather than 250. So there are techniques for estimating population size. We are doing systematic sampling grids over the area where they're known to exist, and then you can work out from the effort there what the actual population is. So yes, they are a rarer population relative to the other bats like pipistrelle and so on in the UK. But we're not talking about a biological population of 250 bats. That's just not the case. You're talking about something in the region of 10,000 plus, I would say, and it's probably considerably under-recorded, I would estimate. But from a conservation perspective, it's prudent to assume it's on the lower end of the scale, so that's why we sort of look at 5,000 to 10,000. Even at a population of 5,000 bats, we're talking about a fraction of a bat in terms of annual mortality. So you have to remember it's an annual addition. It's mortality anyway, and we're talking about additional mortality to the population. And that additional mortality is next. The bats will be dying from natural causes, from being eaten by bats or being predated by whatever, or even other causes of flying into trains, or that kind of thing. So it's we're talking about a very, very small offtake from a population. So hopefully that clarifies the population question. I can explain a little bit. I am not a lawyer, but I can explain a little bit of the background to the legal situation here as well. For development, it's incidental mortality of a European protected species is allowable. The issue becomes if there's intentional or recklessness, and the definition in that area is if it starts to affect the biological population. So if the impact's significant at a biological population size, then that's where it becomes an issue under the nature conservation regulations. And this case law deals with that point. I don't think it's part of the core documents, but there's a case law by RWE versus Eaton 2012, which goes into that in a lot of detail. But in very basic terms, there's a distinction between incidental mortality and intentional or reckless. And this is why it's important to have a proven mitigation scheme in place, and a mitigation scheme which can be adaptive as well. So it's proven, it's based on evidence. We'll come on to this in a bit, so I won't go into too much detail. Proven based on evidence, but adaptive to make sure that these tests under the law are also met, and also which also tally exactly with what we're trying to achieve in this assessment here of working out, is the effect significant at population size, which I've explained isn't. Do you want me to go on to discuss other bat species apart from Lislaw?
If there's information that you have that you want to bring before us, I think what Mr. Stevenson was raising concern about, that the proposal may have impact on other species like the common pipistrelle as well. But I appreciate that that isn't on the agenda. So if you're able to touch on it, that would be helpful.
Yeah, sure. No, that's no problem. I can do that. Well, the bat mitigation and monitoring plan, which is part of the core documents, technical appendix 8.4 of the environmental statement, and also the SNH guidance. It talks more about the mortality studies that have been done, because this is important in the context of how effective this curtailment mitigation is, and explains that there is a relationship between that's been found between bat activity and mortality. So yes, at these reference the test sites, they found mortality of pipistrelle bats, common pipistrelle bats, and they tended to be in the region of I think it's about 2 bats per turbine per year, or a wee bit more than that in some cases. So they did find with higher activity, and so obviously pipistrelle activity is, as I've said in my papers, for Arecleoch anyway, it's about, I think, 40 or 50 times higher than Lislaw's. So you're talking about way more flight activity on the site, feeding activity. So in these cases, they're picking up mortality of bats, and that's what they tested the effect of looking at that mortality before the mitigation and then after, to assess whether they've been successful in addressing it and reducing it to a level which is considered to be acceptable. And in this case, for these test sites, they didn't detect any mortality after the mitigation. So it's a very effective system.
Okay, thank you, Mr. McGregor. Before we move on, Mr. Stevenson, is there anything else you want to say in relation to that first topic?
Yes, thanks very much. On the last point, Mr. MacArthur, and the common pipistrelle, where you say that there is a mortality rate of 2 per turbine per year, has there been assessment done in relation to 200-meter high turbines, the ones that are proposed for Arecleoch? particularly, perhaps not so much with the common pipistrelle, but particularly for the Leisler's bat, which is a high-flying species.
Are you able
I think
to?
that the assessments from the different sites take account of quite a range of different sizes of turbines. I don't have all the details of these sites with me, but there's some newer sites which will tend to be larger turbines and some of the older sites which have been centered longer ago. I think in terms of, I think you'd probably find bats tend to forage at quite low levels. Leisler tends to forage a wee bit higher than the pipistrelle, above sort of canopy height, but they also forage close to the waters, sort of if it's a lock or something along the surface for insects. So they forage where the insects are basically, and that tends to be not really high up where you've got more wind. It tends to be in areas where you have the wind is disturbed by trees, whatever, and that's where you get the insects congregating. So I wouldn't expect, if anything, I would expect a inverse relationship. As the turbines get higher probably, and the rotoswept areas further up, you'd probably have lower bat mortality, if anything, I would expect.
And would the impact of barotrauma be intensified by the gigantic size of the 200-meter wind turbines?
I don't think it would make any difference with the rotation speed. The rotation speeds, I would expect, is probably slower. So deviating into sort of rotation speeds of turbines is not my area, but I expect they are slower. And the difference will be fairly negligible. It's the air pressure shift that causes with the turbine blade swept. So I'd expect that be, that air pressure shift change, which causes has been shown to cause barotrauma, would probably be very similar between any turbine, because they don't vary that much in the rotation speed. We were talking about modern turbines.
Just one final point, ma'am, on the legal question. I did refer to the Bristol report of 1995. In that report, they do highlight the legal aspect, where they say it's a criminal offence to intentionally or recklessly disturb a bat in its roost or deliberately disturb a group of bats. Now, having heard that it is illegal to deliberately take, injure or kill a wild bat, and having heard Mr. MacArthur saying that in case law the incidental mortality is allowable, is the incidental disturbance of a bat roost or the disturbance of a group of bats, is that also allowable in case law? Because it seems to me that there is a definite intention here to kill at least 2 pipistrelle bats per turbine per year, and at least half a Leisler's bat, a very rare species of Leisler's bat. And again, I'm just wondering whether this is a deliberate intention in case law.
I think Mr. MacArthur's probably already given us his views on that. Obviously, you're entitled to give us your view as well, but I don't necessarily need anything further from you, Mr. MacArthur. I think you've already answered your understanding of the case law.
Or even on the question of disturbance.
I'm certainly comfortable that I understand where the position is in terms of the intentional and incidental. Mr. MacArthur, do you want to answer anything further on that?
No, the only thing I would explain is that roosts, you check so that the law is quite clear on roosts. You avoid disturbance to roosts, and that's why we do surveys during the ES to work out where they are. but there's also follow-up surveys before construction and so on, so the data's absolutely, fresh, and you to make sure there's no roofs there that are going to be disturbed. So that's just, it's a normal part of the process of developing a site, that you have to take your reasonable measures to check for protected species. And some of these protected species are European protected species like otter and bats. You undertake the relevant surveys to make sure that you found their holts or their roofs or whatever, and ensure adequate protection measures are in place.
Okay, thank you. Thank you for that, both of you. Can we move on to the second question in relation to ecology, which is the impact of red aviation lights on the matter? Reference has been made to 2 studies, so I don't know whether people want to get those before them, which is the Voigt et al. Study, which is CD 12.3, and Spoelstra et al. CD 12.2. And Mr. MacArthur, you stated in your hearing statement that the paper by Voigt et al. Relates to long-distance migratory bats, and therefore its findings aren't relevant to this proposal. Mr. Stevenson, I think you've referred to that as something that you consider is relevant. So I suppose I'll maybe go to you first, Mr. Stevenson. Do you want to explain the relevance of the Voigt et al. Study for the proposal before us?
Yeah, thanks for that. I'm just looking for the reference. I think I sent it to you yesterday. Well, first of all, this is again because of the lack of information about the liceless bat. We are not entirely clear whether it is a migratory bat. And I found from the Vincent Trust in Ireland, I'm just trying to find that reference, where they claim that it is a migratory species of bat.
That's CD 22.12.
Okay, I'm just trying to find that reference here. Yes, CD 2212, where they say the liceless bat is considered to be a migratory species with several long-distance movements being recorded. So I would say that's a direct challenge to Voigt et al. And shows that this is indeed relevant. I accept that the Vincent Wildlife Trust is based in Ireland, where there is quite a large population of liceless bat. But, it's interesting they make that assertion when they are experts on the liceless bat. And Mr. MacArthur is saying the opposite.
Okay.
Yeah, just to follow up on that, I'm not sure whether maybe misquoting that website. So they talk about continental Europe. So they are known to be a migratory species, a long-distance migratory species in continental Europe, but not in the European islands. So, including the UK or Ireland, it's not migratory. There's no evidence found from any radio tracking studies that they are undertaking long-distance migration. So it's only dispersal that's happening within the island rather than the migratory movements, which is over thousands and thousands of kilometers, basically.
Okay, I accept that.
Thanks for that explanation, Mr. MacArthur. I was then going to ask both parties to clarify their understanding of the implications of the Spoelstra study for this proposal. Mr. MacArthur, could you maybe explain first of all, and then give Mr. Stevenson an opportunity to come in?
So the Spoelstra study is more relevant. I mean, it's still been undertaken in continental Europe, but its focus was during the breeding period of the bats. And it overlapped a little bit in the later end of the year, August, September, so it might have caught some of migratory movements, but its focus was over 5 years over this migratory period, over the breeding period, the activity period of bats. And the kind of, there's different species groups that they looked at, but in a couple of these groups, one of them included Nyctilis, which includes Lysla, and another one includes Pipistrelle genus as well. So over these 5 years of study, they detected no attraction to red lighting by Nyctilis bats, Lysla, or Pipistrelle, but they did detect attraction of Pipistrelles to white and green light spectrum, and they conclude that that's likely to be because insects are also attracted to that spectrum, so Pipistrelles are attracted to the insects. So because of that finding, they advise, there's a quote there that I've got my paper I can read out, they advise that red aviation light should be used in red aviation lighting should be used and green and white lighting should be avoided. So that's more relevant, albeit it's in continental Europe. It studies the similar species groups. It's more relevant than Voigt, which was very, very focused on the migratory period of the 4 weeks of the peak migratory period to work out what the bats are doing during that time.
Thank you. So is it your position then that with the use of red lights, that won't add to the risk of mortality to bats in the area?
Yeah, they found that the difference between red and a dark control was nothing. There's no difference between having a red light on or no light in terms of activity. So they found no relationship at all. So yeah, so red aviation lighting, it's definitely the kind of safe lighting to use. It will make no difference to bat mortality.
Mr. Stevenson, you want to say anything in relation to the lights, in particular that study, if you want to reference it?
No, I'm still rather surprised that Voigt et al., which is a more recent report, did conclude that there was a problem with red lights. Again, I would say this is an area that's not well established scientifically. And I think there is a further need for caution about red lights, given that we haven't done extensive research on 200-meter high turbines, which means that the red aviation warning lights will be at quite a high level in the nacelle. Also, there are the column lights that are fitted to the turbines. It seems to me that if there is a risk of any kind at all, that this could amplify the possibility of bat mortality. And, you know, Voigt et al. Must be taken into account, surely. Thanks for that.
I think just to
Sorry,
respond to that.
You want to come back? Yes, on you go, Mr. McCarthy.
Okay. Yeah, but Voigt does address that directly in his paper, what the contrasting findings as he sees it, and explains them. You know, the reason for them, and that migratory bats tend to use visual cues, likely to use visual cues when migrating, whereas foraging bats are using echolocation and are not using the same sensors, basically. So they switch on, migratory species switch on, the sensor that they need to migrate, and that's why we're not seeing this relationship in feeding bats during the breeding season. So there is a nice, he sums it up pretty clearly in his paper in section 4.2, if you wanted to look at that, where he says it's surprising that the attraction effect of red LED light on Pipistrelle pygmaeus, which is soprano pipistrelle, to a less extent than Pipistrelle enthusiast, which you don't have at the site. At the Latvian migration corridor stands in contrast to the findings of Spolstra attack.
Sorry, can I just stop you there, Mr. Garza? Can you give me the paragraph reference again?
Oh, sorry. Okay. So it's section. If you go to section 4.2, and it's of Spolstra.
Yeah.
I'm sorry, Voigt.
Voigt, yeah. I've got 4.2 Voigt.
Yeah.
Page 9359. Yeah.
So it's the last paragraph in section 4.2.
Okay.
So the paragraph that starts previous studies on light.
Yeah, got that. Thank you.
So if you just go down to the third sentence, you'll see it starts. However, it is surprising.
Yes, thank you. Got that.
Okay. So it's, however, it is surprising, excuse me, that the attraction of red LED light on Pipistrelle pygmaeus, which is soprano pipistrelle, which we have in sight, to a lesser extent on enthusiast, which we don't have in sight. The Latvian corridor stands in contrast to the findings of Spolstra. We argue that this difference is not caused by methodological differences or differences in experimental design, but rather by condition-dependent effects of artificial light at night, that's Alan, on bats before and during the migration period. So it goes on and explains, it is noteworthy in this context that a context-specific response to light cues has also been discussed for compass orientation in bats, that is, non-migratory bats use solar cues for orientation, whereas migratory bats did not. And just as a final section here, we speculate that migratory bats may be more susceptible to light sources of a specific wavelength spectra because vision may play a more important dominant role than the echolocation during migration. So, that's suggesting why you're likely to have that difference. So they're using different sensors, different internal sensors to migrate than they do when they're foraging and echolocating.
Thank you. Mr. Stevenson, anything more you want to say on impact of the lighting before we move on?
I think that's pretty comprehensive coverage. Thanks. Okay.
So the last question then in relation to ecology, which we have touched on earlier, is to get an understanding of the proposed mitigation, because at the start we talked about the predicted mortality rate, but that was pre-mitigation. So we note that Nature Scott, formerly Scottish Natural Heritage, supports the mitigation measures that have been proposed by the applicant in the EIA report in the bat mitigation monitoring plan and chapter 16 of the EIA report. It would be helpful, Mr. MacArthur, if you could provide a sort of layman's summary for the reporters to understand how the mitigation works and the implications of that for the predicted fatalities.
Okay, yeah, that's fine. So it'd be worth having the SNH et al. Document to hand. So that's CD 12.1.
I've got that, thank you.
And also the BAP mitigation and monitoring plan, which is CD 12.1. Oh, sorry, CD 1.4.
Okay, just 1 wee minute. You got have you got a figure reference for that?
For the bat mitigation monitoring plan.
Yeah, please.
So it's CD 1.4.
Which I think is one of the technical appendix.
Oh, sorry, technical appendix 8.4.
Yeah. Lovely. Okay. Got that.
Okay. So if you were just to look at page 37 of S&H et al. CD 12.1. So that's appendix 5.
I've got that. Mr. Stevenson, are you following this as well?
Yes, I've got it. Thanks.
Good, thank you.
So, okay, thanks. So the reason I've referred you to this is the case study of the operational curtailment implementation. So this is giving brief results on how effective this approach is, and it has been trialled at another wind farm already, and this is the results showing how it's worked. So it has been proven to be effective, as it mentions here, in you'll see paragraph. Let me see, sorry. And page, yeah, so just to refer you to a paragraph, one of the key paragraphs in it, on page 38, it says under curtailment strategy, second paragraph, it just says, following activation of this system, no bat carcasses were detected at any of the curtailed turbines during year 2. So year 1, they didn't have it in place, year 2, they did. And given the high probability of carcass detection using trained dogs, teams, it can be concluded with high confidence that the total number of bat fatalities is either 0 or close to 0 to be undetectable. So that's a result of that. I'm just giving you the result first of the effect of the mitigation before I explain a little bit more detail behind it. So this curtailment mitigation is implemented via the software system that's operational on these turbines, the SCADA system. And what happens is the required parameters that they've worked out when the bat activity is the highest, these parameters are fed into the SCADA system to automatically curtail the turbines during these conditions. So the conditions that turbines are curtailed at, the weather parameters, so when the wind speed is less than 5.5 meters per second and the temperature is higher than 9.5 Celsius. So when the wind speed drops, you tend to get more bat activity because obviously there's more insects coming out to forage on, and when the temperature is high, there's also more insects. So these are the ideal conditions for bat foraging when there's much more pre-availability, so they get much more return for their effort. This study, so that's more precautionary than the parameters in the study. The study talks about above 11.5 Celsius and below 5 meters a second. So the curtailment that's proposed here is going more precautionary again, and it's below 5.5 meters a second and above 9.5 degrees Celsius. So these parameters are fed in, and that operates between when the bats are active during the period of the year bats are active, and that's 1st of April to 31st of October. So that period covers the kind of extremities of their activity period as well. Quite often, bat surveys in Scotland don't start until May because it's not really warm enough earlier on in the year for you to get really any meaningful activity of bats. And by the time late October comes, There's very, very few bats active because of the temperature and pre-availability. They start going into torpor or hibernation at that time. So that system is put in place. It works automatically, and it explains in the bat mitigation monitoring plan how that's would be audited as well to make sure that's happening. But a key thing with this, it's been tested and proven as evidence here to give us confidence that this will reduce bat mortality to very low levels. But the important thing here is that it is monitored. The effectiveness is monitored as we go on, and it's consulted. The effectiveness is continued to be assessed, and the discussion is had with under the condition it's the local authority and Nature Scot obviously being the key advisor. So the results of that, the mortality searches, the effectiveness of the monitoring would be undertaken annually until agreed otherwise by Nature Scot and the local authority to ensure that that mitigation has been effective. There's high confidence that it will be, but we want to make sure that it's working, and in that way, it's back to the legal issue there that we can, Scottish Power can be confident that they are what they're doing, the way they're operating the site is acceptable, and from a bat legislation or biological population impacts perspective.
Thank you, Mr. MacArthur, for that explanation. Mr. Stevenson, would you like to respond, or are there any other outstanding concerns you have in relation to the proposed mitigation?
There are 2 points that I'd like to ask Mr. MacArthur. The first, on the question of feathering. You say in the EIA, which is paragraph 243, in proposed mitigation, you say that the mitigation measures would be implemented at each turbine between the months of April to October, between sunset and sunrise each year, for the lifetime of the proposed development, unless monitoring results provide further evidence to justify modifying mitigation. Now, you say that the feathering will take place at points when the wind speed is so low that you couldn't generate electricity. Well, in those instances, the turbines are not working anyway, is my understanding. So is it really valid to claim that this is a mitigation measure? The second point on the mortality monitoring. First of all, I've never heard anyone telling me in the locality that they've seen sniffer dogs being used in the area, either at the existing Arecleoch wind farm or at Arecleoch. So if you could enlighten me on whether that's the case. But I also raise the question here, if a bat is killed during the night, during their feeding activity or at dusk, surely scavengers like foxes are going to eat the carcass. So I'm not surprised that you don't find any evidence of bat mortality, and I don't see that that is, again, a relevant monitoring activity to say you're monitoring dead bat activity with sniffer dogs. I'm sure the sniffer dogs cannot tell you if they've sniffed a place where a dead bat had lain. Maybe I'm wrong. Maybe they're very clever sniffer dogs, but it seems to me that the 2 proposed mitigation measures are spurious. Thank you.
Okay, Mr. MacArthur, so 2 points then. Do you want to clarify in terms of the feathering in relation to the wind farm being operational, and secondly on the missing evidence if others get in before the sniffer dogs appear in terms of that?
Okay, well, Okay, thanks. I'll start with the scavenging one first. So that forms part of these surveys. They actually put out carcasses that they have already, and test how long they stay there. So cameras are set up to work out scavenging rates at the site, and the estimate that they get is adjusted for that level of scavenging rate. But it is a factor, an important factor to consider in this kind of thing to make sure we get a really accurate and precise result. We need to know what the scavenging rate is in the site, and that varies between sites depending on what scavengers are there, many foxes and crows and so on. So that's taken into account in it, and it's important to make sure that's there to get the correct information. With the actual mitigation practice, the norm for the turbine's UNIS period is to idle, and that idling is usually at a higher RPM, which can cause mortality, and it's been proven in studies that is that impact. That's a kind of the small area where bats come into conflict in terms of collisions, because it's when the wind speed is at that low level, when we're having more insect activity, and the turbines are idling faster before the cut-in speed. It's about that period there that the mortality happens. So feathering the blades and reducing that rotation speed to a very low level does have that impact of reducing mortality, as we've seen, to very low levels, to the point they're undetectable. So it does reduce the rotation speed significantly to stop collisions.
David, do you have a question?
Yeah, that's. I was wondering. So when idling means they're turning, but they're not producing electricity, and what this does is make them idle more slowly. Am I understanding that right, Mr. McCall?
Yeah, it's before now. The actual I'm not sure the levels for this site at which it starts to cut in and starts generating electricity. That's another specialism. But when they're idling, it can be rotating fairly fast to switch on, basically when the wind gets to a certain point. So it's feathering it during that phase to make sure that they're not turning at speed and reducing the RPM to, I think it's 1 RPM.
No, that's fine. Every time I've seen a wind turbine turning, I just assumed it was always generating electricity. So you've put me right on that point. That's fine. I think I understand what you're saying there, Peter. Thank you.
There was one more point that Mr. Stevenson made. He was asking whether sniffer dogs had been used at Arecleoch and Kilgalloch. Do you know anything about is that currently used as bat mitigation for those wind farms?
I'm not sure I'm not certain. I don't have that information here on if they were the operational Arecleoch site and the existing Kilgalloch site. I'm not sure if they form part of that study.
Okay, that's fine if you don't know the answer to that. That's us come to the end of the questions on ecology. Is there anything else you want to raise, Mr. Stevenson, before we move on to transport? Sorry, you're still on mute. Do you like to unmute yourself?
Just on that final point, if sniffer dogs have not in fact been used in that existing area where the liceless bat is known to exist as one of the few areas for the liceless bat in Scotland, I would say that is a serious problem. Thank you.
So the site was in the southwest Scotland, where that's reported on in the SNH guidance, where lislers are definitely present. So I can confirm that.
Okay. I think that comes to the end then of the first part of this morning's hearing. Probably a good point for us to take take a break, allow us to get our papers ready for the second part. Thank you very much, Mr. MacArthur, for your contribution. 11:02. If we say we come back at 11:15, that enough break, and it'll be your colleague Miss Reid then on behalf of the applicant.
That's fine.
Okay. Is that okay? See you at 11:15.
Thanks, Mr. MacArthur.
Okay, I think that's us all back. This is us moving on to second topic for this morning's hearing, which is topic 6 relating to access, traffic and transport. Now I know I see Miss Reid, welcome. Is Mr. Gannon joining you as well for this session, or is it just yourself, Miss Reid?
Yes, he should be joining. I believe he's with the applicant.
Okay. I see an applicant box, but I don't see him there. Maybe just Mr. Gannon, are you there? Morning, Mr. Thompson.
I'm terribly sorry. Yes, we're here. Joanna Reid is joining us remotely, and Mr. Gannon is here. So when I go off screen, he'll come on.
Excellent. That's fine. We've got Miss Reid on screen, and you can hear us okay, Miss Reid?
Yes, I can.
Good. Okay, so in that case, we will press on with the first matter under access, traffic and transport. Relates to the volume and nature of traffic. And Mr. Stevenson, in his statements of case, raised concerns regarding volume and nature of traffic on the local road network. And we have noted in the agenda that in section 3.1 of your response statement, Ms. Reid, dated 30th of October, which is CD 15.10, you've provided some detailed information taken from the EIA report on traffic volumes within the context of existing traffic levels and nature of traffic, which will use different access points and routes. So really wanted to give you, Mr. Stevenson, an opportunity to respond to that information and explain any outstanding concerns you have, specifically in relation to the volume and nature of traffic.
Thank you very much, and good morning, Mrs. Reid, or Miss Reid, sorry. Yeah, in my statement of case, not being an expert in this area and looking at the massive quantity of rock material required for infrastructure purposes, I think we were talking about 122,413 cubic meters of rock material. I was alarmed, given the nature of the narrow, twisty roads in this area, about the impact that the transportation of that quantity of rock material onto the site, assuming that all of it has to come onto the site, the impact that that would have on the local road networks. Now, I note Ms. Reid's response to that, but I just wonder if she could illuminate perhaps the reporters further on, to give us reassurance that this will not be the case. We will come on to the access issues. I am slightly at a loss whether the only access will be at Wheeb Bridge, or whether, as stated in the EIA, and if I could just find that for a second.
It's paragraph 64 of chapter 12 references the access and the split.
Yeah, I am looking actually at 2.7.2.1 site access, where it says that HGV construction vehicles would mainly use the access from Wheeb Bridge. However, it's anticipated that the site entrance at Bent's Farm may be used for some construction traffic and also used for light goods vehicles. I mean, the Bent's Farm access, which I know, is a railway bridge, which is of such construction that even tractors and trailers can't go underneath it. So I haven't seen anywhere in the EIA that it's the intention of Scottish Power Renewables to build a new access at Bent's Farm, or whether in fact that's inaccurate, and whether all access will be at Weed Bridge. And that being the case, there are issues there for local residents that I would like to raise separately. Thanks.
Okay, sort of two main points there for you, Ms. Reid. It'd be helpful if you could come back on. One is in relation to the assumptions that what volumes of rock material will be imported, which would then result in obviously transportation movements. Secondly, if you can provide any clarification on the use of Bent's Farm access as well as Weed Bridge. Thanks.
Yes, of course, thank you. So the first point made, the quantity of rock, Mr. Stevenson, as you quoted, it was calculated to be 122,430 cubic tons of rock. This volume has been assumed as the worst case. So I will.
Sorry,
back.
Ms. Reid, could I ask you to come a bit closer to your microphone? It would just losing sound a little bit. You're going in and out.
Is that better? Sorry about that. It's a microphone as part of a headset, so let me know if there's problems again. So the volume of material has been assumed as a worst case, with no material being brought on site, and so the 100% of that volume quoted has been assumed to be brought to site from external sources. I will touch on the fact later that there have been borrowed pits identified on site. So the absolute worst case is in this case an unrealistic worst case. The volume of material has been distributed evenly over the construction period, which is an 18-month period, and we've assumed that there would be 18-ton HGVs, so there would be loads of 18 tons, and with the 27 working days per month during that 18-month construction period, we essentially apply all of those, which gives us an average of 14 loads or 14 HGV trips per day, which is a one-way movement. That's the transport of the material into the site. So you would obviously then have a returning trip with empty vehicles. So that would be 28 two-way movements per day. In terms of the relative impact to the local roads, that would translate to one vehicle trip per hour or two-way movements per hour, which, as we've identified within the chapter, is an insignificant number of HGVs. Relating that to the nature of the roads, the A714 access into the site would be gained directly from the A714. By nature of the road, it's not narrow, it's not windy, it already has a reasonable percentage of HGVs as a percentage of the total traffic. So that route is used currently by HGV. An increase of one HGV per hour or two-way trips per hour is not deemed to be significant on a road of that nature, and that conclusion is drawn within chapter 12 of the EIA. Point 2, the access. So Mr. Stevenson referred to paragraph 2.721 of what I believe is chapter 2. In chapter 12, we go into a little bit more detail. It's confirmed that the majority of HGV crossing the site, and as Mr. Stevenson pointed out, chapter 2 refers to it as the majority. We've identified that as being approximately 80% HGV traffic would access the Weeb access.
I'm losing your sound again. I'm not too sure whether others.
Sorry, I'm not sure why. I'll perhaps recap. So
yeah, I think one of the things what we find with others as well is sometimes whenever you're turning paper at the same time as speaking, the microphone's picking up that as well. So take your time and sort of turn your papers and then speak, and that will hopefully help us. Thanks.
Okay, yep, noted. Thank you. The chapter 12 of the EIA goes into a little bit more detail about the distribution of the HGVs in terms of each of the two access locations. And we do identify that the WE Bridge access would see approximately 80% of the HGVs, with 20% accessing at the Bents Farm access. That's obviously been based on conversations with SPR and their experience gained while constructing the operational Arecleoch site as well as Kilgalleoch. The HGV distribution is slightly different. Sorry, the LGV, light goods vehicles distribution, is slightly different, with 80% approximately assumed to access at the Bents Farm access.
Okay, thank you. And I see there's detailed information in chapter 12. Mr. Stevenson, is there anything you want to comment back in relation to the information provided by Ms. Reid?
Yes, thanks. I'm grateful to Ms. Reid to clarify that 20% HGV traffic would use the Bents Farm access, because we have to understand that the Bents Farm railway bridge cannot accommodate HGV traffic under it. Not even a tractor or a float for cattle can go under that bridge. So, you know, it seems to me alarming that you have predicated 20% of HG traffic using a route that is not capable of accommodating that traffic, and will in fact mean major structural works to the railway itself and the bridge, if you intend to go ahead with that. If you abandon that idea, it means 100% of traffic will be at the Wheeb entrance. I also question the point you made, Ms. Reid, about the A714 not being bendy or narrow. Prior to the lockdown, I was frequently using that. I must say I have not noticed the huge volume of HGV traffic that you seem to refer to. Using it, any HGV traffic I've ever seen on it, if it wasn't farm traffic itself, it was traffic going to the existing wind farms, which is, of course, something that annoys the local residents. But it is an extremely narrow and windy road. There are frequent signs that indicate there are S-bends for miles to come. So, you know, I'm not sure if you have taken a careful study of the A714, but certainly it doesn't sound like it to me. Thank you.
Okay, certainly David and I have travelled along the A714 whenever we were out on site visits, and again we will be going back once we're able to, so we'll be able to take our view on the nature and character of it and the traffic. I'd be interested in more information on that, sort of the Bents Farm and the in relation to the railway bridge. I don't know whether it's yourself, Ms. Reid, or Mr. Gannon. Was that entrance used as part of the construction of the operational Arecleoch?
My understanding is
yes,
it was. It was used, and my understanding is that there was agreement with Network Rail for that access to be used. There was a person stationed at the bridge to ensure that the vehicle movements through that location was undertaken with care, as to avoid any striking or damage to the structure. And it was possible for HGVs to use that access, and they did use that access. In terms of the nature of the A714, I appreciate that it is a windy road and may well be narrow in places. It is obviously used by HGVs, both as part of previous wind farm construction, but also in relation to forestry within the local area. So I was purely making the point that it does have HGVs on, and has done historically, and is likely to in the future.
Thank you. Thank Ms. Reid. Anything more, Mr. Stevenson, in relation to the volume and nature of traffic, or can we move on to question 2?
Well, I'm glad, ma'am, that yourself and your colleague, David, will both be looking at the Bents Farm access, and you can take your own assessment of the evidence you've heard. Thanks.
Okay, that's now the second question relates back to experience from the construction of neighbouring wind farms, and this is a matter that I think will be coming up in this afternoon's hearing as well, but obviously keen to have the discussion with Mr. Stevenson as part of that. So in your evidence, Mr. Stevenson, you referred to a number of negative transport related impacts that were experienced during the construction period of the neighbouring wind farms. I suppose what's keen to do from both sides is we've got suggested condition in relation to traffic management plan, and I assume that the existing wind farms also had similar conditions. So it's really just sort of the views from both parties in terms of whether any lessons learned from the construction of previous wind farms and the impact it had on the road network and local residents could be used to feed into a potential condition or the mitigation here if permission is granted. Mr. Stevenson, do you want to outline your concerns first of all, just to start the discussion? He seems to have dropped out. We'll just give him a wee minute. I've noticed his image had frozen. We'll see if we can get him back. Mr. Stevenson, can you hear us? Give him a wee minute and then maybe take a break and see whether we can speak to our IT support, see whether we can get him back in. He might need to come out and dial back again. The flicker there. Okay, can I maybe suggest we take a 5-minute break? I'll stay on the call just to make sure that somebody's here if Mr. Stevenson comes back. 11:33. If we come back at 11:40, if you want to take a break. Apologies for this.
Can you hear me now?
I can. Excellent. Yeah. You just your image froze and then you just dropped off. So we took a break until 11:40 to in the hope that you would be able to dial back at 10. So good to see you.
I had to switch everything off and reboot, so I'm again. If you just give me a couple of minutes.
Yeah, no, that's fine. You do that. No problem at all. Might be got a slight flicker of your screen there, so it might be we need to do what we do with some of the others and ask you to turn your video off if that helps. But we'll see how we go.
Okay, I have everything back on screen.
Let's wait for the others to come back. It said 11:40, so.
Thanks.
Excellent. I think everything's back. I'm well glad to see Mr. Stevenson's face again. So we were just starting question 2, which relates to the experience from construction of neighbouring wind farms. I'm not sure how much you heard, so I'll just recap of what we said. This is a matter that will come up in this afternoon's hearing as well. Obviously, we discussed the issues raised here raised by Mr. Stevenson in his evidence. And it basically relates to the negative impacts that the construction of previous wind farms had on the local road network and local residents. And we're just interested to explore with both parties whether any lessons learnt from the previous experience can be used to inform either the traffic management plan or other mitigation in relation to this proposal if permission is granted. So I was going to invite you, Mr. Stevenson, first of all, if you wanted to briefly summarise the concerns that you have and any suggested mitigation that you think would be appropriate.
Yeah, thanks. I'm sorry that my system let me down, but I'm back now. I was referring everyone to CD 21.18, which is a series of photographs of a delivery truck for the Arecleoch wind farm site on the private road to Dockroyal Farm. Now, you will see from these photographs, the lorry is embedded in a ditch. This is a tiny unsurfaced road full of deep potholes, completely unsuitable for heavy vehicles. But this apparently at the time.
Sorry, Mr. Stevenson, can I just interject one? Ms. Reid, have you managed to find that document? That's fine. It's just sometimes difficult to locate. On you go.
At the time of the HGV access to Arecleoch, this was the third truck in 3 months that got stuck. The driver in this case had the postcode of Dockroyal Farm on his docket. He could speak no English. He'd driven past the entrance to Arecleoch, which had no signpost on it, despite assurances it would be signed for HGV access. And he had apparently driven through the UK with illegal tyres and a chipped windscreen as well, which may not be relevant to this. I said in my original statement that this kind of incident amounted to irresponsible behaviour on the part of SBR and their contractors during the construction work in the area. So when it causes blockages in areas like this, you might appreciate that the people who live at the top of Dockroyal Farm track, where this particular photograph shows the vehicle had blocked the access, they were then stuck for several days. They couldn't leave their homes, they couldn't access a doctor, emergency services couldn't access them. So this is completely unacceptable. And, you know, we've always get all sorts of assurances why all sorts of actions will be taken to ensure that this sort of thing doesn't happen, but it does frequently happen. We see damage to roadside walls and bridges. I just heard Miss Reid saying that at Bent's Farm there was somebody always on duty to ensure that if there was any HGV access at the railway bridge, and I still question that. I think it was small vehicles only. But if there was HGV access, that they didn't damage the railway bridge. In fact, there is damage, existing damage to roadside walls and bridges caused by previous HGV traffic accessing wind farms in this area, which can still be seen to this day. So this causes an extreme nuisance to locals and can often actually affect their livelihoods. So I really want to say to the reporters that the kind of assurances we've had in the past, and there have, as you know, been extensive wind farms, they have not been worth the paper they've been written on, frankly. Also, is this an appropriate time to raise the question of Emma Assels and Rob Leach at Arnimeen, the residents located at their small holding at Wheeb Bridge?
Perhaps I'll allow the applicants to respond on kind of the general points that you made on in relation to Miss Spence's property and general damage to roadside walls and bridges before we go on into any other deep matters of detail.
Okay.
Ms. Reid or Mr. Gannon, do you want to respond to that within the context of your traffic management plan or other mitigation that you're asking us to consider?
Yeah, this will be Mr. Gannon. Thank you.
Certainly. I think whilst the points that have been highlighted, I've certainly highlighted that issues have occurred. I think it's important to stress that the traffic management plan that we prepare is based on a lot of our experience from previous construction sites in the area and also a much wider experience delivering other wind farms. So we are very much adopting a position of best practice. It is then passed to the local stakeholders such as the local roads authority for feedback. So we don't prepare this document in isolation without understanding some of the issues that may occur. We try and preempt them as much as we can, and then we use the expertise of the local roads authority to also support that. I think the particular issues that have been raised with regards to people taking wrong turnings or missing signs certainly shows that from that experience we need to reinforce future traffic management plans with even more signage and ensure that we make the obligation that we will implement that before the development starts. Hopefully that should address the issues, but the other important point is that we continue to audit adherence to the traffic management plan. As we do, if a planning monitoring officer is engaged, then they will also be able to audit that, and we do take the feedback of local residents very seriously. And whilst issues have been raised, I hope there's also an acceptance that we did deal with them robustly and quickly when they were identified to us. There's absolutely issues which can't be foreseen.
Can I just step in on that one? And in relation to some of the other issues that we've had for the inquiry, we've discussed what happens when things go wrong. So I was wondering, is there anything in the traffic management plan that would that sets out what the procedures are whenever something like the photographs at Miss Spence's property, who would be informed? Is there a mechanism to inform? Is it the wind farm operator? Is it the local authority? Any views on what happens when the draft management plan doesn't work?
Yes, I mean, we're certainly happy to include that in the traffic management plan and make that obligation. I was about to say that issues do occur which can't be foreseen either with our best intentions, based on our experience of the area or other wind farms, or also even based on the experience of the local roads operator, for instance. So it is important that we are able to react and we audit. So yeah, we're happy to make that a commitment that will be a mechanism in place and a formal process to ensure that we can react to issues which such as the ones highlighted. I don't know if it's maybe appropriate that add in some of the things that we actually do contain within our overall site management plan, which people may not be aware of. They may just see isolated issues occurring, but not understand the actual management that we undertake to avoid a lot of potential other issues, such as we implement buddy systems for new drivers. So if a foreign driver comes to site, they won't be allowed onto the public road network unless they've had a buddy who's familiar with the roads for a period of time. We've got signage when leaving the site to make sure that foreign drivers know, for instance, which side of the road to drive on, make sure they know where they're going. So there's a lot of measures that we implement behind the scenes, if you like, which help prevent other issues occurring. But certainly the issues that have been highlighted, we could include an obligation for a process to help avoid that occurring in the future.
Mr. Stevenson, have we lost you again?
I hope not. Can you hear me?
Oh, I can hear you. We can't see you, but we can. If that's good that we can hear you. Oh,
you can hear me. I'll switch off and switching on my video again.
Okay. Yeah, can I see you again? But most important thing is that we can hear you. So if anytime that I can't see you, I'll check that you're there.
Obviously, the internet is going in and out somewhat.
Yeah.
But...
Okay. Well, we'll keep pressing on and keep our fingers crossed. Would you like to respond in relation to any of the matters raised by Mr. Gannon?
Well, yes, Mr. Gannon seems to be saying that he's passing some responsibility to the local roads authority rather than maintaining that responsibility for the Scottish Power Renewable. I do agree with him that there has in the past been signage. I would say that I've seen a sign at the egress from Mark Hill farm that says "Circula por la izquierda" in Spanish to remind people to drive on the left-hand side. There has not been adequate signage when the Kilgalleach and original Arecleoch construction took place. This is part of the problem. So, you know, giving guarantees that there will be adequate signage and then not undertaking to ensure that happens is what causes great dissatisfaction and frustration with the local community. And that is the point I'm trying to highlight. I think
Mr. Stevenson, we were losing your sound there. Do you want to try and turn your video off to see if we can keep the sound? Okay, speak now, if you can. That's unfortunate because Mr. Stevenson's connection has been pretty good on the other days that we've had at the last time he had to go all the way out and come back in again, which obviously took a few minutes. You there, Mr. Stevenson?
Can you see me?
We can. We didn't get. I don't know whether you were speaking there. You've just come back to us, so we didn't get anything of what you'd said before. Before that.
Can you hear me? Okay now.
We can hear you and we can see you.
I'll switch the video off.
Right. That might secure the sound a bit better. I think the last thing we had from you when you were saying was that the signage hadn't been put in place at Arecleoch and Arecleoch.
That's right. So I was suggesting that it's something that frustrates and annoys the local populace greatly, that we get all these assurances from Scottish Power Renewables that they will do all of these things, and then in fact they don't, and you end up having a lack of signage which causes trucks to go in the wrong places, and they get bogged down and roads get closed. So really it's not good enough for Mr. Gannon to say that SPR want to pass responsibility or share responsibility with the local roads authority. They also have to take more responsibility themselves. I would hope that the reporters will take that into account. Thank you.
Thank you, Mr. Stevenson. Anything more the applicants want to say on that matter?
The only point I wanted to reinforce is we are not abdicating responsibility to the local roads operator. But what I think is very important is that we take their experience and feedback into account in our traffic management plan to ensure that it's not just SPR's view, that we accommodate the views of other key stakeholders with a lot of experience in the area to help prevent any issues. The final point is it's completely noted regarding signage, and it's on us to make the commitment that we'll ensure the signage is in place prior to commencement of the development.
Thank you. Now, Mr. Stevenson, you referred to Arnameen. We're aware that there was a letter submitted by the new residents at Arnameen, and it was agreed that that would be accepted as a late document within the context of private water supply, because other parties had already raised evidence in relation to Arnameen. But it's not before the inquiry in relation to road matters, so the applicant won't have had sight of that. But if you want to raise an issue, Arnameen's the property adjacent to the Weed Farm entrance. If you want to make a point generally about impact at that entrance, I'm happy for you to do that.
Thank you very much. I appreciate there isn't even a document listing number for this particular letter, and I'm grateful that you did take it. I am rather concerned about the implication of access traffic at Wheat Bridge for Emma Astles and Rob Leach at Arnameen. This is a small holding located at the Wheat Bridge. This young couple invested their life savings in a yurt and sauna business, which even during the pandemic, their Airbnb business had actually been a great success, and that has, begun to repay their investment. They are now saying that the people who come to them as clients, when hopefully the lockdown ends, they do so because of the beautiful views of the River Cree, the dark sky, and all the other things that we know and love in this area. But if we're talking about 80% of HGV traffic and potentially 100% of HGV traffic entering the site by Wheat Bridge, it could relatively not only impact on their business, it could destroy their business and their livelihood. And I would very much appreciate if the reporters could take that into account. Thank you.
Okay, thank you, Mr. Stevenson. I mean, just to clarify for Ms. Reid and Mr. Gannon, I understand that the occupiers in the business has they moved in since you'll have done your work in relation to the EIA, so it's not something that you could have addressed in relation at the time that the application was being submitted. But I don't know whether you want to make any comment generally on the impact of the access road on residential amenity or other
Yes,
matters.
if I can, as touched on earlier, the assumptions within the EIA were worst case and assumed that the full volume of material required on site would be brought in from external sources. That is not the case. It will be the case that the material will be sought on site. And so the predictions that saw two-way HGV movements per hour would not happen. The material that's required for the construction will be sourced on site as part of the borough pits, and so those additional those vehicles predicted as part of that worst case, those HGV movements, the 14 trips a day would not be seen. Any HGV movements associated with non-material deliveries would be far lower than that worst case predicted. And so the worst case of one HGV trip per hour, I don't think is obviously the worst case, and as stated, is not likely to happen.
Okay, thank you for that. I think that perhaps covers that matter. Could we move on to item 3, which is the last one in relation to this topic, and that was the suggestion by Mr. Stevenson in his response of 6th of November, which is CD 22.5, that the applicant be required to deposit a financial bond to fund remedial work and cover the salary of an independent inspector. So we just want to give the applicant an opportunity to respond to this, and whether it's something reporters or the ministers have as an option available to them under current legislation. And I see Mr. Thompson's come back in for that one. So, Mr. Thompson, would you like to respond first, and then I'll give Mr. Stevenson an opportunity to comment.
Well, I think that Ms. Reid was going to respond first, and then I was going to say something about the legal position. But if she makes the initial explanation, and as I say, I'll then mention the law on the subject.
Okay. Thank you. Over to you, Ms. Reid.
Sorry, could you repeat the question, please?
Yes, certainly. It's on the agenda that Mr. Stevenson suggested in his response of 6th of November, which is CD 22.5, that the applicant be required to deposit a financial bond to fund remedial work caused by transport impacts and cover the salary of an independent inspector in relation to this matter. So we're just giving the applicant an opportunity to respond to that suggestion, and I think Mr. Thompson's going to cover the legalities of it. But is that something that you've come across before, or is it a suggestion that you think has got merit?
I've not got experience of individuals being paid specifically to undertake a survey of damage to highways. However, what is often the case is that a survey of the road condition would be completed beforehand and monitored during construction, and then a survey would be completed post-construction once the construction had been completed, and that through discussion with the local roads authority it would be agreed what damage had occurred as a result of the wind farm construction, and then a discussion would be entered regarding costs and making good of that damage. But with regards to an individual being employed specifically for that purpose, I'm not aware of that.
Thank you, Ms. Reid. Mr. Thompson, do you want to come in terms of whether or not that would be an option for us?
Yes, thank you, Adam. The position is that there are broadly two types of road, private and public. The A714 is clearly a public road maintained by the local roads authority. There is specific legislation relating to extraordinary damage to a public road, but this legislation doesn't cover private roads, which we'll be discussing this afternoon. But so far as a public road is concerned, it embraces the main carriageway and includes the verges and bridges. And the provision is that if the local roads authority incurs extraordinary expenses as a result of damage caused by excessively heavy or other extraordinary vehicles or traffic, they may recover that additional expense from the person who caused it, which is known in the legislation as the operator. Now, that's the basic provision. There are often practical difficulties for the roads authority in showing how a particular operator caused extraordinary expense to be incurred. So there's a second provision which enables an agreement to be reached between an operator and the roads authority before work such as this begin. And a composition payment can be agreed between the operator and the roads authority in advance of the use taking place. And it provides a means by which the roads authority can recover a fixed sum, whatever happens. And it relieves them of the difficulty of attributing any additional expense to the particular operator. And there's an arbitration provision in that, so that if the operator elects to go down that route and the parties can't agree what a reasonable composition payment would be, an arbiter can determine it. And then after the works have taken place, that payment can be paid. The source of this is the Roads Scotland Act 1984, and it's section 96. 96.1 provides the basic liability provision that I mentioned, and subsection 3 provides for the composition payment. And the second part of the composition payment is, of course, if that's been agreed, then it relieves the contractor, the operator, of any further obligation under subsection 1. But essentially, madam, this is a matter between the roads authority and the operator, in this case, the applicant. The applicant is more than happy to enter into discussions with the roads authority on this matter. It would be a matter between the applicant and the roads authority if a bond was appropriate. The applicant would be prepared to put forward a bond in this case, but it's essentially a matter between the roads authority and the applicant, rather, I would suggest, than a matter to be the subject of a condition. This no doubt could be touched upon again tomorrow afternoon. But so far as this session is concerned, that's the position.
Thank you, Mr. Thompson. That's certainly very helpful, and in relation to increasing my understanding of the intricacies of it. Mr. Stevenson, would you like to comment on anything that's been said either by Ms. Reid or Mr. Thompson?
Yes, thanks for that, and thanks for that explanation, Mr. Thompson. I would hope, ma'am, that if it's your mind to recommend approval, I certainly hope that that will not be the case, but if it is your recommendation for approval of the Arecleoch extension, that you will make this a condition along the lines that has just been explained by Mr. Thompson, where an advance compensation agreement could be accepted and a bond agreed with the Roads Authority. That is, however, only covering the question of public roads. As Mr. Thompson said, this legislation doesn't cover private roads, and private roads, as the photographs we referred to earlier showed, suffer considerable damage on occasion. What is the method of compensation in those cases? Because you cannot expect people who live in these very remote rural areas to have the financial ability to take Scottish Power or other large energy companies to court for compensation. This is one of the reasons I was asking for the kind of facility we're talking about for the public roads to be made available also for the people who use and require their livelihoods to access the private roads. Thank you.
Thank you, Mr. Stevenson. Has the applicant got any comments in relation to that, or any previous experience in dealing with damage to private roads?
Madam, it was our intention to deal with that this afternoon in the infrastructure session. My understanding was that this morning's session was confined to public roads, and that the difference was going to be that private roads were going to be part of the infrastructure dealt with this afternoon. And we're prepared to address the matter then.
Okay, I mean, that's certainly, there is a lot of overlap in between this thing. But Mr. Stevenson, is that okay? I mean, if you want to attend this afternoon's hearing, you're welcome to do that. If you want to participate in relation to that matter, that's you're open. That's open to you, or that you can leave it to the Mr. Andrews and Ms. Spence to address that.
Sadly, I can't attend this afternoon. I have another pressing engagement, but I leave it to your good judgment to deal with this this afternoon.
Okay. I think certainly Ms. Spence was is referring to the same photographs that you referred to, so I think we will be looking in detail at the impact on private roads with her example as a to address that.
That's fine.
Okay, is that us covered everything then in relation to the topic 6, access, traffic and transport? If it is, then I suggest that we again take a 10-minute break and move on to topic 7 on Pete. So I'll just thank Ms. Reid and Mr. Gannon for their contribution to this section of the hearing, and we'll reconvene at 12:20.
Thank you.
Thank you. Okay, that's 12:20. So that takes us on to the final matter that we're looking at this morning, which is topic 7, peatlands. Now I'm conscious of time. With 5 questions on relation to peatlands, but I think some of them are really matters where we're seeking some clarification. So hopefully we should be able to go through those quite quickly and then focus on others for discussion. Mr. Thompson, do you have Mr. Duncan there with you?
I do indeed, madam, and we'll pass them over right now.
Lovely, thank you very much. Good afternoon, Mr. Duncan. Welcome.
Good afternoon. Thank you.
That's good. We can hear you loud and clear. Have you got a copy of the agenda?
Yes.
Good. Well, we'll just press on. In relation to the first topic, it's really just to seek some clarification. Mr. Stevenson had highlighted a potential discrepancy in the figures in relation to the sample points taken, and I was just looking for you to explain that for us.
Yeah, that's fairly straightforward to explain. We did 2 phases of peat probing. Phase 1 was the 100-metre grid that was done initially, and that's used to define the extent of peat on the site. And that was where we did 882 data points. The second phase, which is the more detailed peat probing, we did 881 data points. And that's when we go back and we look at turbine locations, tracks, infrastructure. And at that point, we do some peat coring and condition surveys to look at the quality of the peat. So the combination of the 882 and 881 gives us the 1,700 plus sample points. The 1,700 sample points are then used to aid in doing the peat landslide risk assessment. And at the back of that, which was in Technical Appendix 10.1, the Annex A had all 1,763 points. And that's used extensively for the peat management plan and the risk assessment. So that data is all available, and all the data has been taken using GPS. So we have exact coordinates of it, we have exact depths, and we have an interpretation of what's below the peat. It also allows us to categorize the type of peat it is in combination with the condition survey. So we're aware of the type of peat, how dry it is, how wet it is, how affected it is by groundwater, etc.
Thank you very much. That answer your query, Mr. Stevenson?
Not quite. There is a third figure which confuses me even more. And that was the figure of 1,804 surveys, which was listed in SPR's EIA. So I'm not sure where I see, what Mr. Duncan is saying about the 2 different phases, giving a figure of over 1,700 surveys, but where does the 1,804 surveys figure emerge from?
Part of that will be the condition survey, the probe points. There'll be some validation data. What we're saying is that it's over 1,760 data points, and for the peat slide risk assessment, that's what we used. I think at this stage, a difference of 30 or 40 is just something that we've decided to either not use because it's not relevant to the risk assessment, but it's not an issue as far as we're concerned.
Well, I'm sorry to say this, Mr. Duncan, but it is an issue where you're forcing members of the public like myself, who have no particular expertise in this area, to have to deal with 3 different figures, which leads to a great deal of confusion and does not honestly build an element of confidence in the reports that you're putting forward. But anyway, let's move on.
Just to clarify, the three different figures are actually based on two initial reports. One that had 880, one that had 882. The risk assessment combined those and used the data that was available that was relevant to the site. So there are actually three reports, technical appendices that are all in there, and they're available for public use. I
think that's helpful, and certainly, I mean, that's the level of clarification that David and I need in terms of moving on. But thanks for raising that question, Mr. Stevenson. Now, the second question really comes from ourselves rather than directly from Mr. Stevenson's evidence. I'm just looking for some clarification. It would be quite helpful if you could get out the map in relation to its figure 10.1.5 in your technical appendix 10.1, which is CD 1.5. It's the map that shows peak depth greater than 0.5 meters.
Got that.
Okay, and so the question that we had, the response from SNH, now Nature Scots, then it welcomed the micrositing of all turbines to areas of peak less than 1 meter. And I think in your statement you confirmed that that was the intention, that none of the turbines would be located on land below where peak was more than 1 meter. The question I had really in relation to micrositing. Now, tomorrow we'll discuss the merits of micrositing, the distances involved in micrositing, but suppose today what I'd like is the principle of moving turbines distance, whether it's 30 meters or 50 meters, either side of where shown on the map, seemed to my reading to then potentially take turbines into areas of greater depth of peat. And I was really just looking for an explanation on the implications of that for peat if they're moved some distance into areas that are over 1 meter in depth.
The initial selection of all the turbines was based on a number of constraints, and one was obviously to avoid deep peat. And Nature Scotland asked us to review turbine 9, which we did, and we moved it to the south. I have to say it's quite difficult to see this scale, and we really looked at all of these at a bigger scale. But at the moment, all of the turbines are on less than 1 meter, and they are in the best environmental position as we see it at the moment. That's not to say that when we go to actually build it, there may be some reasons for moving it, but at this stage, we believe that the turbines are in the best environmental position.
Okay, perhaps I can clarify that the ones that I've just noted from my reading of the map, and I note that the scale may be something that you can explain, but turbine 5 has an area of pale green, which is over 1 meter just to the west of it. And turbines 7 and 13 have yellow, which is over 2 meters to the north and east. Would those areas be beyond 30 or 50 meters from the turbine location?
Any movement would be done during the construction phase, and the ECOW who would be involved in it would decide along with the Scottish Power project team whether this was suitable or not, whether it was acceptable from an environmental remit. So it would only be done then. But we cannot move at this stage because we've got we believe the best position at the moment.
Okay, that's helpful. I mean, we can discuss the detailed wording of the micrositing policy at tomorrow's hearing session, but it's useful to have that explanation from yourself. Mr. Stevenson, this wasn't a matter you raised. Is it something you want to comment on?
Only to say I'm sure you will take into account any micrositing's impact on private water sources.
That would obviously be taken into account, but I can't comment on that. I think it's already been addressed.
Yeah, that came up in discussion at the private water supply inquiry, and will be looked at again in the conditions hearing tomorrow. But thanks for that point. And that's it. Can we maybe move on to question 3, which relates to the impact of floating tracks on peatland? Mr. Stevenson raised concerns about the impact of new and upgraded tracks within the site. Just be useful if you could give us an explanation of the concept of floating roads and how any potential impacts would be addressed through the peat management plan or the construction environmental management plan. Mr. Duncan.
Yeah, the plan is to have about 20.9 kilometres of road on the site, of which over 14 kilometres would be reusing existing roads. So we've tried to minimise new roads, new excavated roads and floating roads. And the extent of floating roads is roughly 1.5 kilometres. The reason it's floated is to go over deeper peat and to try and avoid digging out excess peat. The concept of floating tracks, you may or may not be aware, is a proven technique. It's not perfect, but as long as it's managed properly, it can work on site. It has to be done at slow pace. So you basically lay a geogrid onto the surface of the peat and slowly build up the road surface. By doing it slowly, it allows the site to initially consolidate slightly. It then compresses the peat slightly, and it gives it some inherent strength so you can build the road. After that stage, you will get settlement, a little bit of settlement, and if it's managed properly, you can minimise that. These roads are designed to handle heavy vehicles, and during the construction phase, that road will be able to cope with it. There has been instances in the past of roads sinking. That's usually down to poor management and poor construction on site. As I say, it's not ideal, but it is a proven technique. It's been used in Scandinavia, Canada, America, and it is one way of crossing peat.
Thank you. Mr. Stevenson, you obviously had raised concerns about this. Is there any more information that you would like, or any further comments you want to make?
Well, as you say, I have listed in writing my comments on this, and Mr. Duncan has answered the only question that I was going to have about slow controlled loading. So given his answer, I mean, I do not agree that floating roads are a viable concept, even although they have been extensively used. I do think that they tend to cause disruption to the surrounding peat, but perhaps that's something that we can come on to in the next item. Thanks.
Okay, thank you for that. Well, that then neatly does take us on to item 4, which is relation to groundwater in peat. So in your statement of case, Mr. Stevenson, which is CD 22.3, you state that damage to peat can extend as much as 250 metres on either side of turbine foundations and road infrastructure. Whereas the applicant in their hearing statement, Mr. Duncan, you've stated in section 3.14, that's CD 15.19, that drawdown of groundwater around the infrastructure is likely to be less than 5 metres. Obviously, quite a difference in opinion between parties. So it would be helpful to us if both of you could provide sort of more detailed explanation. Mr. Duncan, maybe ask you first in terms of in relation to the information provided in your EIA documents, and then I'll give Mr. Stevenson an opportunity to come back.
Firstly, can I just clarify that it wasn't less than 5 metres? I said it was generally as little as 5, and generally it could be up to 15 metres. So there is a range there.
Thank you for clarifying that.
Yeah, there is a range there. Peat has got very, very unique properties. It is usually, pristine peat is usually saturated with water, but it is has very, very low permeability, so water doesn't move easily through it. One of the reasons it is saturated is because it doesn't drain to groundwater. It is completely saturated. So when you dig or excavate close to it, you want to seal the peat in, or you want to shutter it. But basically, when you're building either a track or a crane pad or a turbine on site where you have peat, you try to excavate as quickly as possible and fill the space that you've basically excavated. The drawdown is very limited. We have done modelling in the past on various sites, and we know that the peat doesn't draw down that far. It's very limited, and if you can replicate any drainage, etc., the drawdown will be minimal. There's certainly no evidence that drawdown can go as far as 250 metres on any site, and that's been used throughout the Scottish industry, and there's been plenty of research done on it to prove that peat doesn't draw down. The actual water in peat just doesn't transmit through peat very quickly. It's very, very slow. It sits there. And when you do expose it, there are methods to basically stop it from draining or coming out the bottom, usually in peat pipes. And that's either by shuttering it when you're doing excavation or sealing it by using turfs or wedging the peat down to stop water draining. So there are a number of techniques to manage it. That's all from me.
That's helpful. Thank you, Mr. Duncan. Mr. Stevenson, do you want to provide further explanation on your concerns and your statement in relation to the 250 metres?
Yes, as you know, Madam, I supplied additional documents. One of them is the Richard Lindsay School of Health and Bioscience, University of East London, on the Lewis wind farm proposal. So that's CD 22.13. And I don't want to read the whole appropriate section out, but he concludes that he found that ditches could affect the water table as far as 250 metres away on a particularly wet site. And this was, his discussion about infrastructure work on deep peatland. So together with CD 22.14, which is the IUCN, the International Union for the Conservation of Nature, the UK committee, peatland Programme Briefing Note number 12. And again, I won't go into detail there, but...
Can I just stop you 1 minute just to check that, Mr. Duncan, have you got sight of those documents?
I have the IUCN document.
That's fine.
I did have a look at it. I don't have it with me, no.
Okay, well, on that basis, well, at least we can perhaps read out if there's particular bits you want response to.
Also,
continue, Mr. Stevenson, on your 22.14.
Do you want me to also refer back to read out the 22.13, the Richard Lindsay School document?
I think that would be helpful in terms of which part of the conclusion you're referring to. It helps our notes as well as giving Mr. Duncan a chance to respond to it.
Okay. In CD 22.13, the Lewis wind farm proposals, they say the calculations...
What paragraph
detailed
number?
Study by Richard.
Do you have a page number, a paragraph number?
I have the document. Can you give me the page number?
No, actually. Let me just check. No, only taking the extract from it. I would have to go back into my memory stick to find it. Can you give me time to do that?
Yes, yeah, please do, because I think it's helpful for us as well.
Right.
You may be able to just do a search on the PDF document using the search function if you type in you know, the first three words of that phrase, it might find it for you.
No, I think I'll need to find the actual document. So it's CD 22.13.
That's right.
No, I can't see that now.
I typed in 250 meters and I got 3 references, and one of them's in the chapter 7, the summary, point 16, which says, consequently, it's possible to make a conservative estimate of the zone over which impacts from the wind farm may be felt.
That's not the one I was going to relate to. It was one that said the calculations are based on 3 scenarios.
Okay, I'll put in 3 scenarios, see if I can find it.
I'm sorry about this. I should have noted the paragraph and the page.
As I search for the word scenarios, I get no results from that paper. I also typed 250 and I get 6 results, but none of them were the one you referred to, Mr. Stevens.
Right, I've found the actual document now. Would it be helpful if perhaps I just refer to this in final submissions?
I suppose the difficulty we have is that what would be useful would be to ask Mr. Duncan's, as the technical expert from the applicant side, his comments on it. But it's obviously difficult for him to do that without the reference. But if we can't find it, I think we'll just need to move on. Do you want to refer to 22.14?
I could just make a comment on that if you want.
Yes, please.
The 250 metres, that's a figure that's been bandied by Mr. Lindsay for many years, and it has been proved on a number of occasions on a number of wind farms. We can give you a list of those wind farms where it's been proved that it's much less. Large ditches can drain peat. It's used when you're extracting peat. It drains the top surface of it. But in this instance, we're talking about local drawdown from infrastructure, and that impact is very, very short. And as I say, between 5 and 15 metres has been modelled using piezometers, which are used to monitor groundwater in wells. So it's actually been done, and the whole idea of during construction is to replicate drainage and to backfill any excavations as quickly as possible. so that we can get back to a scenario where the peat rebounds to its current situation.
Well, I think
Thank you, Mr. Duncan.
that
You want to
effectively answers the point that I was raising on, Mr. Lindsay's report on the Lewis wind farm.
Thank you. Do you want to say anything more about your CD 14?
Yes, on CD 2214, that's the IUCN report. Mr. Duncan says he does have that in front of him. I think you'll find it's on page 2, the second paragraph, where it says without mitigation to reduce their environmental impact. I won't read the whole thing, but what they're basically saying is we would assume that the proposed floating track, what I'm saying based on IUCN, I'm assuming that the floating track at Arecleoch will in fact subside with consequent damage to hydrology and surrounding peatland. So it's the cutting up of the peat bogs with roads and hard standings which degrade bogs by draining them, and of course increases flooding lower down. So that's really the thrust of the IUCN argument in that paragraph.
Mr. Stevenson, that just reading the text that's highlighted in yellow there is on constructed tracks, but right below it there's a different section which is about floating tracks. So shouldn't we be looking at the one about the section on floating tracks rather than you're quoting from the one on constructed tracks, which I take to be not the type of track we're talking about here? I mean, there are other constructed tracks in the wind farm, but if the concern is about floating tracks, it seems to me the relevant text would be in the white text, the white box below it.
Well, where we have constructed tracks or floating tracks, it appears from IUCN's view that they will have a wider impact on the peat. So really, I'm posing the question, can we be certain that the floating tracks will not subside?
Mr. Duncan, are you able to provide any response to that?
Yeah, I'm quite happy to respond here. A couple of the issues here based on the IUCN document, they mention the word subside virtually every time. Subsidence to me is failure. Settlement is managed settlement of the ground, and if a floating road is constructed properly, it will settle. The same way as every other building in the world that's built on clays or sands will settle. Everything settles, but you have to manage it. You have to control it during the excavation program. Subsidence is failure as far as I'm concerned. We don't want subsidence. We want settlement to allow the road to create its own strength, to allow you to bring lorries, construction vehicles, etc. onto site. And as I say, this is proven technology. It's been used by forestry, it's been used by wind farms, it's been used all over the world. It has to be done, it has to be managed carefully, and the SEMP, etc. will state how it's going to be done and the time scale it's done in. If it's done in a hurry, it will collapse. If it's done gradually, built up on geogrid with layers of rock, over time, a floating road will float.
Thank you. Anything further you want to say on the groundwater matter, Mr. Stevenson?
No, that covers it. Thanks.
Okay, just on to the last question. And it's really in relation to the risk of peat slides. Now, Mr. Stevenson has referred in his recognition to a recent peat slide which occurred on a wind farm in Ireland. And we just wanted to ask whether any lessons learned from that would have relevance for this proposal, obviously within the context of your peat and landscape peat and landslide hazard and risk assessment that you've undertaken as part of the EIA. So it's really over to you, Mr. Duncan. Are there similar circumstances, or is it a totally different scenario that peat slide occurred?
In this case, I don't believe they are. The mean bog Irish scenario is very different. I've managed to have a look at it, and I've been working with the Irish IWEM on it to look at what happened here. This site is actually, it was a bog burst, and it was created by bad construction practice. They actually blocked drainage, and the water went back into the bog and it burst, and you can see from the aerial photographs what happened there. Now, in the instance that we are looking at Arecleoch, it's a very different site. The whole scenario of, we have our peat is drier, we have less rainfall, but the point is we manage the whole system from start to finish. We understand the peat, we understand the peat risk, we manage peat landslide risk, and that's reviewed and by the government, Scottish Government, by third-party engineers. So we assess the risk, and in this case, Arecleoch, we see it as a negligible to low risk site. The system in Ireland doesn't really do that at this stage. It's quite clear that they don't manage it as effectively as we do. They don't go to the degree that we do to look after not just environmental, but health and safety, because that's where it came from. It was to look at landslides on sites, development sites. So it came from initially the health and safety executives. So two very different scenarios. I mean, I would love to go and spend time and look at every reason why it happened, but it's not likely to happen in the scenario of Arecleoch. It's much flatter site. We have spent a lot of time avoiding the deep peat on the site. You can see from the average of the peat that we found on site that the turbines, the roads, everything's on less than average peat depth. And you can see from the drawing that we looked at earlier, we've avoided all the deep areas of peat. We've also managed to reuse a lot of roads to minimise risk as well. So everything that's done here is very different from Ireland. And I think the scenario is different because in Ireland, a lot of the bog has been worked, and you're getting down into what we'd call amorphous or catatelmic peat, which is much sloppier, gel-like, whereas the material that we have in Arecleoch is much more fibrous. We've done testing, we've done condition testing on the site to test it, and we know that it's a fibrous material. If we dig out any peat on the site, we can reuse the top portion of it. We can use, and certainly anything down to 1 metre could be reused because it's got an inherent strength. So the two are very different sites, and we know that there's been a couple of big peat slides in Ireland, both from very similar scenarios. And the one at Derry O'Brien, and I think it was 2003, was a big classic example of this. It all came down to poor management, and we'll not have that on this site. That's really all I can say on that.
Thank you, Mr. Duncan. Anything further you want to say on that matter, Mr. Stevenson, in light of Mr. Duncan's explanation?
Well, I'm glad to hear that Mr. Duncan has paid close attention to what happened at Meanbog, because it did seem to me when I wrote this into my statement that the site at Meanbog is similar in many ways, because they have Sitka spruce forestry, and Sitka spruce has shallow root systems, which are sort of plate-like root systems. And when you saw the videos of what happened with that peat slide, the whole forest was swept away in the ensuing slide. It was a very frightening, a very terrifying situation. And the people of Bar Hill and the people who live around that area would be horrified if something like that happened at Arecleoch. So I can only say that I hope what Mr. Duncan has told us is going to be a commitment by SBR in the management of this site if it's given permission. Thank you.
Could I just address one other point? That having studied the video for Mean Bog, the area that has moved was up gradient of a track. It was a thick area of peat, and the trees that moved were, it looked worse on the video than it actually was. It was probably half a dozen trees at the edge of a forest that moved, but we are aware that peat slides can do this. They can move large areas of material because you've basically got a slip plane that's fluidized, and it will move large chunks of trees and large chunks of the ground. But as I say, the peat slide risk assessment has been done by SPR, has looked at all aspects of it. It's looked at what was there originally. It was desk-based originally. Then we did the peat probing. Then we managed it. We looked at risk, and it's done on slope stability. So we looked at the impact that agriculture has on it, forestry has on it, any drainage that has on it, and then construction techniques, and that's built into the SEM. So everything that we do has been built into it and has been reviewed. In this instance, it was reviewed by, obviously, the Scottish Government manage it, but they use independent geotechnical engineers who review the peat slide risk assessment, and they were happy with the findings of it. So we are comfortable that what we've done is appropriate for this site. And yeah, these things happen in other areas, but there's been no evidence of that type of slide happening in Scotland.
Well, I'm glad you said that there's no, there's less rain in this area, Mr. Duncan. It's not my experience.
It's marginal.
Thank you very much, Mr. Duncan, for your response on that. Now that takes us to the end of the questions that we've listed on peat. Is there anything else, Mr. Stevenson, that in relation to peatland?
I'm very grateful to you for devoting this morning to these issues, and I think they've been well covered. Thank you.
Okay, thank you. Thank you, Mr. Duncan, for your contribution. So that brings us to the end of this morning's hearing. Now it's almost 1 o'clock. So I think I propose that just for ease, we start the next hearing at 2 o'clock. Mr. Andrews, I see your name on the screen. Are you there? Maybe popped out. We will let Mr. Andrews and Ms. Spence know that we're going to push the time back to 2 o'clock. Hopefully that's okay for Mr. Thompson. So we'll wrap up this morning's session, and David, myself, and Mr. Thompson will reconvene at 2 o'clock with other participants. Okay. Thank you very much, Mr. Stevenson.
Thank you.
Oh,
Hello, everyone. That's us ready, I think, to start the afternoon session. Can I check that everybody's here? I see Mr. Andrews. Miss Spence, are you there?
Yes, I'm here, and the picture's there, but apparently you can't see it still.
We can't see you. Yes, it says that that's something to do with your connection, but I'll keep checking in to make sure that you're there, and as long as we can hear you and you can hear us, then that should enable us to proceed.
Okay.
Okay, get started. Welcome everyone to this afternoon's hearing on topic 8, which is overview of effects and implications of associated infrastructure relevant to the proposed Arecleoch wind farm extension. Now, these are matters which parties did not consider would be adequately covered in the more specific topic sessions. However, inevitably there will be an element of overlap to some of the matters that we've discussed previously, but we'll try to avoid that as much as we can. For anyone watching, my name is Alison Kirkwood, and I'm joined virtually by my colleague David Liddle. We're the reporters appointed to consider the Arecleoch extension proposal and report to Scottish ministers. Now, can I ask parties firstly to introduce themselves? Mr. Thompson for the applicant.
Yes, good afternoon, Madam. I'm Malcolm Thompson. I'm a Queen's Counsel appearing for the applicant. This afternoon, we have two representatives of the applicant. First of all, Alison Sidgwick of Stevenson Halliday. She is an experienced environmental impact and planning and consenting consultant. And then we have Tony Gannon, who is head of project management for the applicant. Because we only have one feed, you'll only be able to see one of them at a time, but they're both here and raring to go.
Lovely, thank you. Thank you. Mr. Andrews? And Ms. Spence, you're all there.
Yeah.
Okay, just a few formalities. Remind parties that the hearing is being broadcast live and recorded for future viewing on our website. Please note that everyone's required to follow government guidance in relation to COVID-19. We'll stop proceedings if we have any concerns in this regard. When you're not speaking, please have your microphone off, and for anyone just observing, can they also ensure they have their camera off? The hearing's scheduled to run for this afternoon only. We'll take one or more short breaks at regular intervals as required. Parties have circulated lists of documents that they're likely to refer to. All of these are on the memory stick provided by the applicant. The hearing agenda, which you should all have, sets out those matters which the reporters consider would benefit from some further discussion. But this does not indicate that other matters covered in written submissions are less important. We have all of your written evidence before us and we'll take it into account. So there's no need to repeat any of this for the sake of it, but you can, of course, take us to it to help explain the point you're making. You can ask questions of each other, but we ask that you do it through us. If in your answers you wish to take us to a relevant section of the document, please allow time for everyone to have this in front of them before proceeding. Is everyone content with the agenda?
Yes.
Okay, good. And are there any procedural matters that we need to discuss before we start? I think that's a no. Okay, let's get started then. And just for a bit of context, I suppose, to clarify what matters we'll include today, I thought it was useful from Mr. Andrews' statement of 6th of October, which is CD 18.1, indicates that this topic will cover all components of the application, with the exception of the wind turbines themselves, and then other infrastructure that the application depends on for its viability. Is everybody happy with that as a scope for today's discussions? Take that as a yes. be useful to start section should be section 3.11 of the applicant statement refers to the description of development, which is set out in section 2.21 of the EIA report, CD 1.2. So you may want to have that in front of you. This really refers to the discussion regarding the implications of extending the existing Arecleoch wind farm. So the plan figure 1.2 in volume 3A of the EIA report shows the application boundary in relation to the existing wind farm. The parties have identified both positive and negative impacts of locating the proposal next to the existing wind farm. I think I'd like to start by offering Mr. Andrews the opportunity to comment on the list of factors which the applicant has set out in 2.21 that it took into account when selecting the site, and perhaps raising any concerns that he has in relation to that. You got that document, Mr. Andrews? If you're struggling, if it's not going to load, I can read out some of them to you if that would help. Okay, so what the EIA says is that a number of factors were considered when selecting the site. There are no international or national statutory designations for landscape nature conservation. No planning policies which in principle preclude wind energy development. Initial desperate studies and wind monitoring on site suggest there's likely to be a good wind resource and the site is available for wind energy development. Potential connection options to the electrical grid system, including the possibility to connect to the proposed on-site substation at Kilgalloch or Mark Hill. Good access from the public road network and potential to share or reuse existing Arecleoch wind farm infrastructure a reasonable distance away from nearest residential properties. Hopefully that summarises the points that made. Over to you to comment on your concerns or otherwise that you raised in relation to the siting of the proposal next to the existing wind farm.
Yes, I'm not quite sure exactly by that concern. I think it was more to do with being a divorce from the original Arecleoch wind farm, but I understand that the applicant has acknowledged that. But I can see obviously why they should want to enlarge the site, as it does neighbour the original site. But my concern really was that I think that the, as I said, I don't really want a precedent being set because there is one wind farm. Therefore, it becomes quite natural, or there's a precedence just to have an accompanying wind farm next to it. And I think that was my concern.
It's the bit that I thought was relevant for from your statement of case, really, I suppose, was section 8, which refers, you say, to the impact and implications of an enlarged site in relation to precedent, industrialisation, and permanency, and how you refer to how the proposal relates to the existing wind farm. But if there's not anything more you want to say onto that's fine. It was really just to give you the opportunity to cover that.
Yes, I beg your pardon. Yes, I have no further, I think, comment on that. Thank you.
Ms. Sidgwick, do you want to add anything to what's in the EIA report? Obviously, we have that as the factors that were taken into account.
No, I think the advantages that are associated with the extension are quite clearly set out in the various documents, in particular the design and access statement, which is CD 1.7, and the reutilisation or utilisation of infrastructure that had been used for Kilgalleoch and Arecleoch wind farms was considered as a positive opportunity when we were considering the design of the site. A particular feature of that was the ability to reuse some of the existing access tracks, particularly some of the forestry ones which were widened for Kilgalleoch. So the opportunity to benefit from that was considered to be a positive. Along with things like limiting the number of watercourse crossings, the potential to reuse borrow pits and other hard standings and things. And I think I would just make the point, we're not arguing that just because Arecleoch or Kilgalleoch gained consent, Arecleoch extension should gain consent. Fully respect the view that an application should be considered on its individual merits.
Thank you. Does that cover that point then from your point of view, Mr. Andrews?
Yes, thank you.
Okay, we'll move on to the second question, which involves yourself as well, Ms. Spence. Now, it also, I don't know whether Mr. Spence, Ms. Spence and Mr. Andrews listened in this morning, but we also covered part of this in the hearing this morning in evidence that Mr. Stevenson raised. And really it's Ms. Spence's statement of case refers to off-site damage and disturbance experienced during the construction phase of neighbouring wind farms, and we're aware that you have reference to photographs that you lodged as evidence of that. Section 3.12 of the applicant's statement refers to the role of the construction environmental management plan and traffic management plan in addressing any of these issues. Now, the detailed wording of conditions we'll be dealing with tomorrow at the conditions hearing. However, it would be useful to hear the views of Mr. Andrews and Ms. Spence about their experiences and problems that they've had previously, and consider how these could be addressed in conditions or mitigation for this proposal if permission is granted. Ms. Spence, would you like to kick things off?
I think that the main thing about this was that when attention was drawn to the things that were going really pear-shaped, and repeatedly, for instance, we on a private road that has to be maintained by 3 lots of residents, we had 3 huge trucks, and you'll see from CD 2118 there's a picture of the final one on my property, making one hell of a mess of the road. And the other points about this are in regard to safety, because that truck had bald tyres, it had a cracked windscreen, the driver spoke no English, and he had a docket with our postcode as the delivery address. He had driven past the Kilgalleoch entrance, having come from all the way up from the south of England with a truck in that condition. And also because there was the thing about signage, which you will see quite a lot of discussion in the Bar Hill Community Council meetings. It took a very, very long time to put signage up, and the signage could only then be seen from the north. But this driver, he spoke no English, and he had a docket with our postcode. Why would he have a docket with our postcode? Surely he should have been given instructions as to where he was to offload this load. I mean, the poor man, this was a Friday afternoon. I had a concert weekend and I had to be in Ayr, and the road was blocked by this vehicle, which could have been very inconvenient. And he, when they finally got him out and they had to reverse him nearly a mile, in the end, it was SPR who finally organised it after I'd called the police because I couldn't understand what the man was saying. This took quite a lot of effort and did a lot of damage to the road, as had the two previous ones that had got stuck on our road. We had made complaints, and I think it took about 18 months for any signage to be put up. The signage then was only visible from the north side, and this man coming from the south, so that's no good. And this is all these instances that you have in CD 2101 are just the tip of the iceberg, the ones that were actually reported to the Community Council. Practically everybody in the area had a similar instance of trucks landing up their driveways and having to be towed out and so on. I mean, our three were not isolated instances. They were just typical of what was going on. I mean, everything that went on at that time showed they showed no consideration for the.
Ms. Spence, can I ask what could have been done differently from the wind farm operator's point of view, in your opinion?
The very first thing that they should have done was to put up very clear signage that this was the entrance to Kilgalleoch wind farm, and that was where they were to deliver the stuff. As it was, they took, well, more than 18 months before any sort of signing, inadequate as it was there. Then there was the matter of when Kilgalleoch was being connected to the grid. Our road was closed for 7 weeks, and basically it was closed from 9 till 5, and then from 6 till 9 at night.
Was this the main road or your private road?
No, this is the C road that we have to drive along. It's the one that goes from Bar Hill to New Luce.
Yeah, I know it. Yes, we've driven along that one. Yeah, know where you are.
And basically, we were trapped in our homes. We couldn't get out at all. The people who were actually doing the work had a weekend off, and they never informed us so that we could have gone out, but we thought we were still fastened in. When we did go down to try to get through, maybe get out at lunchtime and come back another way or something like that, to avoid literally a 100-mile round trip if we wanted to go to the village for something. This didn't, this didn't allow us time to go anywhere, as you can imagine, where we are. I mean, say to go down to Newton Stewart, it takes 20 minutes each way, and you haven't got time to do much in 20 minutes when you're there.
Okay, so I think we've got signage and sort of inconvenience of road closures. Was the other one question that I'd maybe ask you for some information on before I pass over to the applicant is what happened in terms of the any damage to your road that vehicle or the others did?
They took absolutely no notice of it. They never offered to come and do anything about the road. They just disappeared. And I think that was what happened in every other instance. They did damage to the road. You can see from the photographs in CD 2118 the sort of damage that was done. And,
okay, this morning we discussed about the arrangements that can be put in place for rectifying damage to public roads, and we said we would leave the topic of damage to private roads to this afternoon. So we will cover that. But can I maybe hand over to the applicant now just to respond to some of those points that you made?
Sure. There was another thing I wanted to raise.
I'll come back. I'll come back to you and give you a chance to do that. But we'll maybe get the applicant to respond in terms of the signage, the road closures, and damage to your private road.
Okay.
I can respond on some of this, and I think Mr. Gannon can respond on some of the in respect of some of the actual incidents and things. But thinking about the traffic management issues, I was involved from the sort of beginning of the EIA work on the project, and I was made aware of the matters that had raised cause for concern during the construction of both Arecleoch and Kilgalleach, both by Scottish Power and by the local community through consultation, which was undertaken in advance of the application being submitted. Scottish Power prepare traffic management plans for their wind farm construction projects based on industry best practice. And I know Mr. Gannon talked a little bit about this morning, and he referred to the lessons learnt and things and the way in which they do that. I personally have been involved in quite extensive lessons learned sessions associated with some of the onshore elements of their offshore projects, so I'm aware that they are quite a comprehensive process, and I do understand how they work. My understanding is that there were 3 events on the road to Dockroyal, 2 of which were related to works being undertaken by SPEN, and 1 of which was related to the construction of Kilgalleach Wind Farm, which I think is the one in the pictures that Ms. Spence has provided. My understanding is that signage was put on at the entrance to that private road shortly after the incident that Ms. Spence provided the photographs of. And following that, I understand that there were no further incidents of delivery lorries using incorrect entrances and things. As part of the traffic management plan condition, we would suggest tomorrow, certainly, that we can discuss it, but suggest that there is reference to signage on private accesses, be they drives, tracks, and things, and that signage has to be in place before construction starts. I don't know if Mr. Gannon wants to add to that.
Just to echo the points from my colleague here, we take this feedback very seriously. We have lessons learned sessions within the team to ensure that traffic management plans that we have adopt best practice, but also adopt feedback from previous construction sites and also previous sites in the area. So the point here really is that we should install signage on private accesses where the landowner is happy to accommodate that prior to the commencement of the works. Just picking up the point on the foreign drivers, unfortunately, these projects are major infrastructure projects and foreign deliveries have to be accommodated. In terms of our contracts, every contract we have includes the correct delivery routes to site and the site accesses to be used, and also the site contact details. I think this just goes to reinforce, though, that if for any reason a driver does not follow that, then it's important that there is adequate signage there as a sort of safety net to prevent instances that we've had with Miss Spence. In terms of the damage to the road, one of my colleagues from the team dealt with Miss Spence, was engaged with her and paid a neighbour to ensure that the roads could be fixed. So obviously I don't want to dwell on previous cases too much, but really it's important that we take the lessons learned and ensure that there's suitable signage in the future to prevent a reoccurrence.
I suppose just generally following on from the discussions this morning in terms of there's legislation in place in relation to any damage to public roads. What is SPR's approach then in terms of how does it deal with damage to private roads? Is it on a case-by-case basis, or do you have a protocol that is followed?
We have a protocol in terms of there's a formal reporting line for ensuring that these issues can be addressed, which I understand was communicated to the Community Council. But in all cases, in all our projects, it should be communicated to the Community Council prior to any works commencing. It is, however, on a case-by-case basis. In the case of Miss Spence, when, for instance, we paid the neighbour to fix the road.
Thank you for that. Ms. Spence, do you want to come back on any of those points? And you said you had another matter you wanted to raise.
Yes, well, nobody ever told me that there was a neighbour who was supposed to come and fix the road, and nobody ever did come to fix the road. So I'm not entirely sure how I missed that, since there are only 3 of us living on this road. And the damage was actually done to the section of the road that I own. Another point was the damage at the end of the road, and which I think it was a subcontractor fixed. Only unfortunately, the stone that they used to fix the road with was cutting our tyres, and I had about 3 goes on the same wheel, where I'd sort of drive in over this bit of road that they'd had to repair with the wrong sort of stone, and then of course I would next time I left home, I'd drive, and as I got along towards the end of the road, I'd have a flat tyre. So therefore, you know, sit and wait for the AA to come and sort it all out, find time to go and get another tyre, and so on. And my neighbour could tell me that the man at the compound that they had just above the station she was there and was told that the subcontractor who had supposedly repaired the road at the end had used substandard stone because he was whinging about having to come up and say what that bloody woman had said and all that sort of thing. And a slightly satisfying scenario here is that he got out, he parked his car at the end of the road, got out of it, had a look at the road, decided that yes, it was the wrong sort of stone, turned round and found that he had a flat tyre, which was quite nice, really. You know, one of the few things when felt we might be getting a bit of our own back on them because we were so sick of it.
And Ms. Spence, was this something that you raised with was this the operators at Arecleoch or Kilgalleoch?
This is during the Kilgalleoch. So all the instances that I've given you are from Kilgalleoch. It would have been too much of a thrash to go through all the Arecleoch ones as well.
Okay, well, I think that's another example, obviously, that of implications during the construction stage for yourself and other residents within the area.
And when they were putting the cabling in, apparently they took the forestry road that they were using, they put the cabling sort of on a framework over the road, and somebody kindly came and knocked it all down and caused a huge outage of power, which actually killed the hard drive on my computer. And I was actually out at the time, but I found out the time of the outage and so on. It was definitely, and at that point, I wanted compensation because I had to send the hard drive away for all the stuff to be retrieved, replace the hard drive, etc. It took me over 3 months to actually get them to agree to pay what they described as.
Can I maybe step in, Miss Benson? I suppose thinking about what this would mean for the assessment that David and I are doing. Is there anything that that you can suggest could be done to make these sorts of things better next time round if permission is granted?
For a start, they could make any temporary contraptions that they have to make better, and they could make sure that people don't, their own people, because they were the only people going up and down that road, we weren't allowed to use their forestry roads, and so it had to be one of their own people who then knocked it down and caused all the problems. I mean, just general carelessness.
Okay, thank you for that. I'm going to bring Mr. Andrews in at this stage. Mr. Andrews, is there anything you want to say in terms of the impact of the construction phase in terms of your evidence?
Well, yes, please. I am a relative newcomer to Bar Hill, so I've not had to put up with any of these problems that Ms. Spence is describing. But I think it's, however, there are roads in this area where wind farm traffic is not allowed to go down. And these are periodically are used by wind farm traffic. But I think that's a relatively small problem at the moment because I don't think there are any big constructions going on. However, it seems to me that should the application proceed, there has to be, the community has to have a much more direct line to complain when something goes wrong. And of course, the community council may well be that body in Bar Hill that can centralize people's complaints. But of course, but they still then have to get in touch with a responsible person who can take responsibility on behalf of the construction and do something about it. And I think that would certainly be a very positive way forward. And of course, how to encourage the applicant to be responsive. And so in my submission, I think some kind of financial penalty has to be imposed. That this is only because, I say this only because clearly there have been problems in the past. Now that may be a communication problem, or it could just be that the applicant is not, excuse me, not the applicant possibly in this case, but previous constructions have not taken the community very seriously.
Mr. Gannon, do you want to come in terms of, I suppose, responding to, you know, the ongoing relationship with the community and some of the points that Mr. Andrews made about, I suppose what we touched on this morning is what to do when things don't go according to what's set out in the plans?
Certainly. So in the first instance, there's a member of the project team assigned to deal with the community council firsthand. And in the example of Kilgalleoch and other projects as well, we regularly attend community council meetings to ensure that the community council and the locals have a point of contact exactly as been suggested. So we would absolutely commit to that going forward. Just going back to a comment from Ms. Spence, whilst we absolutely understand our frustration with some of the issues encountered, I think it's very important to be clear the distinction between the works that are undertaken as part of the wind farm planning consent, and so the works that the project is assessed on that basis, and then the distinction between works undertaken on the grid connection on behalf of National Grid. And the issues that Ms. Spence was highlighting there, road closures, the sharp stones, etc., they were related to the grid connection works, which are undertaken as a separate package of works, and therefore not assessed under our planning consent. So it's just clear to make that distinction. It doesn't diminish the effect on Ms. Spence, obviously, but I think it's good to be clear that they weren't actually wind farm works which took place. The point stands obviously about engaging with the landowners, ensuring that there's adequate signage prior to commencement of the works, which we're committing to do, and also ensuring that there's a representative from the project team from Scottish Power who are a liaison point with the community council, which again we have done in the past and we will continue to do.
Thank you, Mr. Gannon. Is there anything else anybody wants to say about the construction phase? Obviously, bearing in mind we do have your written submissions as well.
I would like to say something.
Yes, please go on, Ms. Spence.
Regarding who is responsible. SPR are the people who are given permission, or were in the case of Kilgalleoch, given permission. And I think you should consider that SPEN is a subcontractor by definition, because it's the contract from the planning application with the permission is given to SPR. It's not given to SPEN. SPEN is an associated company of the same owner, that's Iberdrola, and basically their connection to the grid is implied as a permission by when it's given to SPR, and so SPR still have responsibility, in my view, and the restrictions and conditions should make that clear. And also that, I mean, that they're making an excuse that things are different. They're not. They're implied in the permission in the first place. So if you're going to give them permission to do this, I think that the fact that they will toss that on to SPEN to connect to the grid, and that will be another load of responsibility. And if
I'll maybe just interject there. It certainly is a very relevant point that we're going to come on to later in the agenda, and I think it sort of goes to the essence of a lot of what Mr. Andrews is saying, is that the proposal that's in front of us at the minute has knock-on effects with the other other permissions that are needed and other types of infrastructure that go alongside a wind farm, and we'll seek the views of parties to clarify, what relevance that has for the assessment that we have in relation to this proposal. But maybe sort of move on from construction phase there, if you don't mind, and move on to item 3, which is, I suppose, about the other infrastructure. Sorry, Ms. Sedgwick, do you want to come in before we move on?
Yeah, could I just sort of make a brief point? I mean, I can talk about grid connection in the next topic, but I just wanted to be clear that there is a suggestion in the conditions that there is a planning monitoring officer, and one of their roles would be to see the enforcement of documents such as the traffic management plan, and that would be an important role, and one which would be covered by condition. The other sort of small point I wanted to make is I understand in the case of Arecleoch, apologies, that there was a advertisement in the local press identifying contact names for members of the local public prior to the construction started. Now, I appreciate it's a one-off publication, if you like, but I just wanted to flag that was done in the case of Kilgalleach.
Okay, thank you for that. Mr. Andrews, you have something else on this topic as well? We can't hear you. If you can unmute.
Yes, excuse me. Yes, well, I was interested to hear about the planning monitoring officer. I think I'm not sure who he or she is employed by, but I think otherwise it is just a recipe for confusion unless there is somebody who will take responsibility to manage or field, shall we say, complaints to the various operators involved in the scheme. And as I see it, the applicant is the instigator of the scheme, and therefore I think they really are obliged to be the to take over the management of complaints.
Thank you for your view on that. David, do you want to come in?
Yes, thank you. I think just a question probably for Mr. Gannon. We'll be talking about conditions, of course, tomorrow. But if you mentioned, Mr. Gannon, that it's normal practice to identify someone in the project team as a liaison and a point of contact. What I thought Mr. Andrews was saying there is, well, if you have a planning monitoring officer as well, then there might be confusion. So, in your experience, I'm presuming those are two quite different roles, but I wonder, or might the same person be both? Might the planning monitoring officer be the same person as the community are able to go to as part of that arrangement? I don't know if that was the issue Mr. Andrews was saying, but I'm just speculating. Is that something which is sensible?
I've certainly not had experience of that role being undertaken by the same person. Given that the nature of the roles are slightly different, generally the point of contact for the public is to come directly to Scottish Power Renewables representatives, because we are able to take action on it. Whereas the planning monitoring officer generally would just have to report to us to allow action to be taken. It's probably a relatively sensible suggestion. I think the practicalities of it maybe don't quite align. What we could certainly give some thought to, though, is the planning monitoring officer having exposure to the comments received from members of the public, which we sort of generally do as good practice anyway, from the planning monitoring officer reports, which are submitted directly to the council generally.
Thank you.
Okay, I think we'll move on if that's all right with everyone. So the next item really relates to some of the ancillary infrastructure that Mr. Andrews expressed some concerns about cabling, power lines and substations. Mr. Andrews, I'll maybe ask you first of all to perhaps summarise what your concerns are in relation to this topic before I pass over to the applicant to kind of explain the consenting process.
Yes, I think my concern is that the applicant has focused entirely on the wind farm scheme itself, and they have not taken into account the manner and way in which the wind farm is connected to the grid, and I think this is a kind of again an abrogation of responsibility. I think that the way in which it is connected to the grid should be a part of the application. I'm pleased, however, that in this case, this has become more of an open issue, or it's been opened up to this inquiry, and but the applicant, I'm sure, will. Don't want to put words in their mouths, but their response again is just that it's not their responsibility. It's not in their brief. It's their sister organisation that's responsible, and so a very notable construction has been divorced from the wind farm itself, and it's quite worrying that these things should be so separated, and but I'm glad that in this inquiry they have that we are looking at them together. So that is my concern, but particularly in this case, the connection to the grid, as I have as the documents have shown, that may well or are going to be on overhead power lines, causing a huge landscape and visual intrusion in the area. And of course, the applicant just washes their hands about this. And again, the community is left in a position where who can they possibly discuss the matter with? And so that is my a huge concern of mine.
Okay, thank you for that. It is important. I can understand why you're raising it and the knock-on implications. What we need to be clear about in making decision is that we're looking at the proposal before us and not the knock-on effects. So whilst we have raised it because you've raised it, I don't want to give you any sort of to mislead you that we'll be making decisions on matters that are out with our scope. In that context, Ms. Sedgwick, are you able to clarify the consenting process for those other elements of infrastructure, both on-site and off-site, the cabling, power lines and substations, to help keep us right?
I'll try my best, and I'll do it in relatively simple terms because I'm not an electrical engineer. My understanding is that there would be an underground link from the Arecleoch extension on-site substation to the Mark Hill substation, and that would be a 132 kV line, and it would be about 2.5 kilometres in length, and it relates to Arecleoch extension only, and the works would be undertaken by SPEN using their PD rights, permitted development rights, because it's an underground line. And the route for that, is, as I understand it, is currently unknown. And Scottish Power Renewables, the applicant, have entered into a connection agreement to allow for the underground route to go through with a grid connection offering of 2023. it's this approach of a separate consenting process for grid connection is an entirely normal process for wind farm development. Planning permission or deemed planning permission is sought through the Town and Country Planning Act or the Electricity Act, respectively, for the power generation facility and for the consent for the grid connection, which is addressed separately. And that is standard practice. I know in this situation we're talking about SPR and SPEN, but it could be any other wind farm developer and SPEN or whatever from that point of view. As my understanding is that Scottish Power Transmission PLC is the transmission licence holder in South West Scotland and is obligated under Section 9 of the Electricity Act 1989 to develop and maintain an efficient, coordinated and economical system of electricity transmission and to facilitate competition in the generation and supply of electricity. The company also has obligations to offer non-discriminatory terms for the connection and transmission to the transmission system, both for new generation and for new sources of electricity demand. SP Energy Networks, SPEN, is the trading name of the Scottish Power Energy Network Holding Limited, which owns the electricity transmission and distribution networks in central and southern Scotland through its wholly owned subsidiaries, SP Transmission PLC, SPT, and SP Distribution PLC. SPEN's trading name is frequently used in documentation and public information. And as I've just said, they're the owner of a transmission licence and they would be responsible for providing the electricity network connection for the Arecleoch extension wind farm.
Okay, scribbling notes away. Mr. Andrews, have you got any questions on that? David, do you want to come in first? David, you'll need to unmute.
Beg your pardon. Just so as I'm picking you up right there on the first part of that, it would be if it was a 132 kilovolt line, if that's underground, then it's permitted development, and presumably, well, what I assume is that if it's an overhead line, then there's a specific consenting process to be gone through if it were to end up, or had it been to end up as an overhead line. That's not development. Is that right?
That's correct. In the case of overhead lines over a certain capacity, they are subject to Section 37 of the 1989 Electricity Act.
Thank you.
Mr. Andrews, do you want to come in on any of that, please?
I'm not sure if it's within your remit, Madam Reporter and Sir, whether you can, you might consider suggesting to ministers that there ought to be on wind farm applications a section where and description much more exact about what they are proposing to do to link up to the grid. But I don't really understand. I don't know your remit, and that, excuse me if I'm saying things out of order. But as far as the now underground scheme, putting the cables underground, this also brings up the matter of private water supplies of people living on that route, and and if that is not something that can go to a planning application, if I understand that correctly, as it's a permissible development, I just wonder how landowners or residents affected by that have a way of interacting with the scheme. Perhaps the applicant could just help us on answering that.
Ms. Sedgwick, I'm not sure if you, in terms of private water supply.
I can possibly answer in part. I'm afraid I'm not aware of exactly what process SPEN go through in terms of their permitted development approach, but they do have a standard approach and things. What I can say is that matters such as private water supply and things will be covered by other rules and regulations and things which will come into play. So the protection, I think that some of the protections that Mr. Robb talked about in his evidence 10 days ago or 2 weeks ago would come into play there, even though there is no formal planning application or Section 37 application as such.
I think that's probably as far as we can go on that matter today, Mr. Andrews. I mean, I understood from at the start of the process, you were concerned that the connection to Mark Hill would be overhead power lines, and I think it came out in the policy section, Mr. Innes, that the intention was to go underground, which probably overrules the reference that I'd drawn attention to in the agenda in Scottish planning policy, which states that underground grid connections should be considered where possible. But it looks as if that's now been dealt with by the Scottish Power Renewables. So hopefully that gives you some comfort on that matter. Okay, Ms. Spence, you hadn't led any evidence in relation to these matters of infrastructure. Do you want to say anything, or can we move on to the next? Ms. Spence, are you still there?
Sorry, it didn't go on mute.
That's a disadvantage when we can't see you. Do you want to make any comment? I know you hadn't raised any written evidence in relation to these matters, but I don't want to exclude you if you've got something you want to say.
We decided that we'd just be repeating evidence, and so I stayed out of that side of things. But I think that the private water supplies, I think mine and my two neighbours are ones that I suppose it has been discussed that might be affected by these things. And I mean, okay, I think my house is near enough uninhabitable at the moment, but that would absolutely finally put the kibosh on it.
We certainly dealt with very detailed evidence on private water supplies at that 3-day inquiry. I think it just came up today in relation to whether underground cabling would have any implications, and I think Ms. Sidgwick answered that in terms of that there would be measures in place, controls, even if it was permitted development.
Would that be in place by this inquiry then carry through to?
Sorry, Ms. Spence, I missed the start of your question.
Would the measures that this inquiry would put in place for SPR then carry through to the SPEN as conditions that they would have to obey?
We'll be looking at the wording of conditions tomorrow, which I think you're taking part in, but we'd need to be clear that any conditions that are recommended relate to this permission and this consenting regime. So we can't overstep what the controls would have to be specific to the wind farm proposal that are in front of us.
For that would be the entire project, that they would apply to the whole project.
Well, can we leave those until tomorrow, and then if there's specific questions on them, we can address that.
Yes,
we can address that then. Is that okay? Because I think we're going to look at the private water supply condition tomorrow, so I don't want to preempt that.
Yeah. Sorry.
Okay.
Another thing that did occur to me is that the community council only meets monthly, and there are months when they don't meet at all, like August and December, so that there are long intervals where, okay, we can connect, make contact with members of the council, but they won't have a meeting for sometimes for as long as 8 weeks. And this is a very long time. If you have a serious problem, which can't be addressed until they contact somebody from SPR or whatever to get it sorted out. There are things that
I think we're maybe straying back to the construction phase, and I think I understand what you're saying. I think it's more a matter of detail to be worked out between the community council and the and SPR, and that would be an appropriate time to raise that. I'd like to press on to battery storage, if that would be okay with parties. So again, this was something that was raised by Mr. Andrews, and it's really just points of clarification I think I'm looking for here. The applicant, in their response to Mr. Andrews' statement of case, said that battery storage has been assessed as part of the environmental impact assessment. I had a look through the EIR report and I couldn't find the exact references, so I'd be grateful if the applicant could maybe point out what sections of the EIA report refer to battery storage.
Yes, I can certainly do that. It's clearly identified in the description of development in Chapter 3, which is CD 1.2 at section 3.2.14. And there it describes where the battery storage would be located. It's described as being within the control building compound. It explains that they would store excess power, which is generated by the proposed development. And then it describes that they would be of steel construction, very similar to shipping containers in appearance. It talks about the sort of size they are. It describes them as being 17 meters long, 8 meters wide, and 4 meters high. They're also shown on figure 3.2 of the EIA report, which is in CD 1.2, volume 3A. And then they are considered by the technical
Just
chapter.
give me 1 minute. I'll just have we look at that. Okay, so sorry, 3.2.
Figure 3.2, which is in CD 1.2, volume 3A.
Thank you.
And that shows their location within the construction, within the control building compound. The technical team undertaking the assessment of the EIA has a full understanding of the development as a whole. They are fully briefed on all the different elements of it at various points throughout the EIA evolution process. It starts at quite a high level description, but by the time they start their detailed assessment work, it's set out in a lot of detail with grid coordinates of things like watercourse crossings and that kind of thing. And there is a section on the battery storage there. And then if you go through the various chapters, you can see that they generally all refer to the description of development contained in Chapter 3, and that is what they have assessed. They assess the development as a whole, but they don't necessarily set out in their chapters assessment of individual items of infrastructure, unless it's particularly pertinent to their discipline. So, for example, the landscape chapter talks specifically about the visibility of turbines. In terms of visibility of the battery storage, they've been deliberately located in an area where there would be some permanent infrastructure associated with the compound, and they're in an area which is surrounded by commercial forestry.
That's helpful, thank you. Mr. Andrews, is there any specific element of the assessment that or the description in relation to battery storage that you're concerned about?
Yes, hitherto, I had always considered wind farms to be really just about turbines, and I see now that wind farms with battery storage, and they're quite reasonable sized objects, is either a development of wind farms. Will all future wind farms have that type of contained battery storages, or is this just a way in which the applicant is perhaps experimenting with battery storage? And because they are not only of a significant size, but there are concerns perhaps about the safety aspects of them as well. And if they are, in a sense, an experimental or a type of object, it is putting them on an upland moor near a village. The best thing to do.
Would you like to comment on the sort of practice of battery storage being part of the wind farm development?
Yeah, yes, please. The sort of taking Mr. Andrews' points, there are a number. I act for a number of developers. There are different developers are taking different approaches to it. There are some developers like Scottish Power who are looking at additional forms of renewable energy that they can combine with their more traditional wind farm sites. I'm aware of them looking at solar on some sites as well as battery storage. I'm aware of some situations where battery storage is being promoted through a separate application process and being added on to existing wind turbines. And Scottish Power have a large battery facility at Whiteley and things. And I'm also aware of some developers who are not including battery storage as part of their application process. Battery storage is certainly a newer technology than the wind turbines themselves, but my understanding is that it is something that the industry believes can assist them in delivering clean energy into the grid. In terms of concerns about health and safety, Scottish Power, any developer will have to comply with any sort of health and safety requirements that are associated in respect of any form of electrical equipment and an awful lot of other things. So the health and safety aspect of it ought to be covered through that relevant legislation.
Anything else you want to comment or ask on that, Mr. Andrews?
Yes, please. It seems to one of the things is that we don't actually know what type of battery is going to be used there. No doubt it may well be the lithium battery, but there are also, of course, hydrogen, the newfangled hydrogen batteries, and I think the lack of information about battery storage containers in this application is a matter that does need to be highlighted. And I also again wonder that as battery storages are a new technology, whether again Scottish ministers should be made aware of this and have some research conducted into it, and with a view that perhaps it is better or to have battery storages have their own planning, a separate planning application, because it seems to me that in this case, batteries are just, if I hadn't spotted the word in the applicant's documents, it probably just would have been overlooked by everybody. So I do wonder whether this is a matter of that should be considered perhaps in legislation.
Thank you. Thank you. You don't need to come in, Ms. Sidgwick, if you don't want to. I mean, that's a suggestion by Mr. Andrews. But if there's anything else you want to say.
No, I mean, I'm certainly not an expert on battery storage, and I wouldn't profess to be. But what I can say is that they've been considered and assessed through the EIA process in the form that we've talked about. They're not experimental. I said they were newer than turbine technology, but they are in use at quite a lot of wind farm sites now. And I can't recall the reference, but in some of the policy documents that have been submitted to the inquiry, there is some clear support from the Scottish ministers to consider the potential for storage as part of wind farm applications.
Thank you.
If I may just respond through you.
Certainly.
Thank you. The battery storage containers, it's not exactly about storing surplus energy. Yeah, I think it's about either modulating the amount of energy coming out of a wind farm, or it's there to use for this black start scenario that was discussed some time ago on policy, where the grid goes down and the system needs a great deal of power or backup power. So I don't, if I may say so, it's not really about storing surplus power. And I believe that it's more acting more like a capacitor in an electric circuit. It may be of help to wind farm generation, but it's certainly, I don't think, about storing power as we would perhaps think of a battery at home or in our cars. So I do take a slight issue there, and again, this shows up a certain kind of discontinuity, and indeed a confusion. And I think battery storage, if it is going to be more prevalent, then really must certainly must require a proper study and, as I say, some kind of legislation. Thank you.
Note your views on that. Now, we've gone on a bit longer than I anticipated without a break. It's now 3:15. We only have one more item on the agenda. How do people feel? Do you want to press on and do item 5, or would you prefer to have a short break and then come back?
Adam, just before we end that item, I just wondered if you might like to hear from Mr. Gannon, who perhaps has more direct experience of how batteries work and the purpose of it on this particular project.
Yes, that would be helpful.
But then it might be appropriate to break for 5 minutes then and then go on to the final item.
Okay, that's a good suggestion.
Thank you.
Thank you. It's really just to allay some of the concerns that were discussed there. As we've said, the technology is proven and operational across the UK and across the world, indeed, which is why we are proposing it. But also the nature of the power used will be to modulate the frequency of the grid. We won't be exceeding the generation capacity of the site. We'll be there as a tool to ensure stability of the grid and stability of wind farm output. So just to make that clear and to allay any concerns on that point.
Thank you, Mr. Gannon. That's helpful. Mr. Anderson.
Thank you. Well, that is helpful and does make things a little clearer. But perhaps I may just draw your attention to the size of these objects. And previously, we've just heard that they are to be sited within a forestry area. But of course, forestry is presumably will be cut down at some stage, or the trees become so large that they become a danger to the site. So, you know, on a 25-year site, or possibly longer than that, it could well be that these very large objects, sized objects, will be quite visible, but when they were not first intended to be. Thank you.
I don't think you need, I mean, you don't need to, it probably takes us into sort of landscape and visual impacts, which we've been have dealt with previously. But thank you for your comments, Mr. Andrews. That's useful. Okay, I think it would be helpful just to take a short break to refresh before we come in for the last item. So it's 15:16 now. So if we say 15:25, we come back in almost 10 minutes. Thank you. Okay, are we all back? Miss Spence, are you there?
Yes, I'm here.
Lovely, thank you. And just wait for the applicant to pop back up on the screen.
Yes, we're back, madam. Thank you.
Excellent. So we're really just on to the last matter on the agenda, which is just really a bit of an opportunity for everyone to kind of provide some concluding remarks. If I can remind everybody that we set out at the start that that this topic covers all components of the application, except for the wind turbines themselves, and other infrastructure that the application depends on for its viability. I suppose what we've discussed a number of matters today, some of which are within the scope of this proposal before us, and others that relate to later proposals or different consenting regimes. So I just really want to give each party the opportunity to indicate what of the matters discussed today that David and I should be taking into account, what impact should we be assessing, and which are not actually directly relevant to the decision for ministers on this application. I'll maybe start with the applicant, if that's okay. I'm not sure if Ms. Sidgwick, you've drawn the short straw for that one.
Thank you, Madam. I think I would just sort of finish on that the development as it's set out in the EIA process has been considered as a whole, and the non-turbine infrastructure has been carefully assessed throughout the design process. It's very much part of the design evolution, and the ancillary infrastructure, if I refer to it as that, is by no means sort of dismissed in favour of considering the turbines and things. There are some very real and tangible benefits which are associated with being an extension. And as I said at the beginning of this, being able to reuse some of the existing infrastructure is a key one. And that has some real environmental benefits related to matters such as a shorter programme, less traffic, and less disruption generally than a greenfield site where there is no existing access track and that kind of thing. The grid connection, which we've talked about, is subject of a different consenting process, but it is to be underground, and at 2.5 kilometres it's relatively short, and the grid connection date of 2023 does mean that if consented, this proposed development could be delivering green energy pretty quickly. In terms of the sort of site generally, it's a site that's considered in the spatial strategy, which is set out in SPP, as a Group 3 site. So it's generally suitable, and the EIA has considered all the impacts of all the different, or all the potentially significant impacts of all the different elements of the infrastructure.
Thank you. Mr. Andrews, I know you were we're keen that we had this session to allow for an overview, and I hope it's been useful for you. If you want, are you able to sum up any final points in terms of what we should be taking into account?
Well, first of all, thank you very much for taking this topic into the inquiry. Well, obviously, I do think that infrastructure is now becoming a much larger concern in wind farms, and I'm not convinced that it's given enough prominence in the various documentation that's been handed out by the applicant. As far as I know, battery containers, for instance, were not part of the first consultation exercise, but I was not actually present at that, and I can't verify that. So and so it does come, and that would have been several years ago. So it has come as a bit of a surprise to find that the wind farm development site is now becoming, I would say, industrialized actually, and I know that it's out with the scope of this kind of industrialization around Bar Hill. I know that's not, but we must talk about what's in the development site itself. But I think that the way wind farms are clearly are developing now, that infrastructure, on-site infrastructure, is becoming really quite a major topic in its own right. And I would really would ask or put forward to the inquiry that I think some kind of measures, planning measures, would be most helpful as guidance, perhaps, for future developments, and of course for our communities. And perhaps finally would just like to say that I don't think I am happy with the way the applicant has put forward these matters, particularly on, say, battery storage, and I regret that I have not been able to source an expert witness to make more detailed analyses of this particular matter. And that is my regret, and I'm sorry if I've let the inquiry down in that way. But I think thank you again, because I think it is important that it has been raised, and I think I'm sure that at other inquiries that this will be looked at perhaps in more detail. Thank you very much.
Right, Ms. Spence, anything else you want to say in summing up?
Just an odd thing. Whilst all these problems SPR seems to think have been solved, we still experience or avoid experiencing the use of the road that runs from New Luce to Bar Hill as a racetrack when the staff at Kilgalleach are arriving and leaving. And it is well known that most people in Bar Hill and the surrounding area avoid their start and end times because of that, and I don't really see why we should. It's all ongoing, and there are also times, for instance, when they're doing nighttime maintenance at Kilgalleach, and they've got the whole thing lit up as though it's Christmas or something. And I think that these are some more things which they should address. And they do not, their employees, their subcontractors do not treat the locals with respect in any sense of the word. People have, when they couldn't get the shuttle bus to the station, people have had dogs abuse from the people working on the site. And I have actually sat waiting for them to let me through and watched a delivery truck doing 99-point turn and knocking the dry stone wall to the ward of Carnley down. Now, the people who lived there, the wife is now dead, but she had dementia, and Joe is well into his 80s, and they're not really the sort of people who can cope with that sort of thing when they've had so many problems. And there doesn't seem to have been any consideration in the way that the employees behave. Everything that happens, everything that goes a bit wrong is always a resident's fault. It's never their fault. I mean, they reversed out. There were, at one instance, they were all parked in a passing place, and one was hidden by the rest, and I was just driving up, and one reversed straight out into my car. Now, he had a passenger, so that passenger could have looked out, but he got out of his van, and somehow I was to blame because I was driving along the road. And that sort of thing it is going on all the time. They think that the residents just don't have a right to be there, and they treat us as though we don't.
Okay, thank you for that. I hope that you've at least found it beneficial to raise some of these matters, both with David and I, and with the applicant. Unless anybody's got anything else, I propose we close today's session. Thank you very much to you all for your contribution. Tomorrow we have the hearing on conditions, which will commence at 1:30. I think there's a bit of confusion about the date that was sent out on the agenda. It's definitely tomorrow afternoon, 1:30. And we're expecting the applicant, the council, Ms. Crosthwaite, I think, and represented by Dr. Connor and Ms. Spence. You should all have the agenda for that, and we'll see you then. Any questions before we finish off? Mr. Campbell.
Good afternoon, ma'am. Just to tell you, I'll have Mr. McGibbon and Miss Lobban with me tomorrow for the conditions session.
Thank you. That's helpful. Mr. Thompson, do you know who's attending on behalf of the applicant?
Well, it's not me. It's Mr. Innes again, and Ms. Sidgwick.
Lovely. Thank you. Oh, well, enjoy your Friday off.
Thank you, madam.
Are you back next week?
Back next week.
Okay, we'll see you on Tuesday then. Anybody else? Okay, well, that's us for today. And we'll see whoever's involved tomorrow at 1:30. Thank you.